This is a continuation of the public panel interview by the Judicial and Bar Council of candidates for the positions of Legal Education Board Chairperson or Legal Education Board regular member representing the Integrated Bar of the Philippines or representing the law students sector. Your Honors, the candidates for interview this afternoon are the following. Justice Carmelita S. Manahan, who is vying for the position of Chair of the Legal Education Board, and Attorney Ana Marie Melanie B. Trinidad, who is vying for the position as Chairperson or representative of the Integrated Bar of the Philippines. May I require the candidates to please raise your right hand so that I can administer the oath? Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview by the Judicial and Bar Council?
Yes, I do.
So help you God. Thank you. Thank you. Your Honors, the first candidate for interview will be Justice Manahan. And the first to interview the candidate will be the Honorable Judge Franklin J. De Monteverde. Judge De Monteverde, sir.
Okay, thank you, Attorney Ed.
Thank you, sir.
Good afternoon, Justice Manahan.
Good afternoon, sir.
Yeah, you look familiar, very familiar.
Yes.
Have we met before?
I've been a municipal trial court judge of San Pedro, Laguna.
Okay. After that, you were with the RTC, di ba?
Yes, Your Honor.
Siguro doon tayo nagkita.
Opo.
Not as a justice, associate justice of the Court of Appeals.
Yes, Your
Sa
Honor.
RTC siguro.
RTC po.
Yeah, I was the president of the PJA 2011 to 2013.
Opo.
Okay, and prior to that, VP ni Tony Eugenio.
Yes, yes, Your Honor.
Okay. Sige, Justice,
Yes po.
when did you retire from the judiciary?
I retired last March 22, 2019.
2019, okay. Now your record shows that you are now a professional lecturer
Yes, Your
at
Honor.
the Manuel Quezon University.
Yes, Your Honor.
And for how long have you been there as a professional lecturer?
I've been there since 1991 up to 1998. And then when I was transferred to the Municipal Trial Court of San Pedro, Laguna, I stopped teaching because I wanted to devote my time in the judicial work. And I resumed my teaching in the MLQ University in 2007 when I was appointed as an RTC judge of Manila.
Okay. All in all, how long have you been actually teaching in the
14
college?
years. 14 years.
14 years. And you have been the professional lecturer of Manuel L. Quezon University for 3 years.
For
Professional lecturer. It shows here 3 years records. Is this correct? Or
other certification, sirs, given to me was nominated as faculty member. Faculty member, yes.
Kindly have this rectified, Justice, no? Kasi
Yes,
sa
Your
records namin, it shows that you have only been a professional lecturer for 3 years lang, yung records mo. Pakitingin lang, ha?
Yes, Your Honor. And also, Your Honor, if I may add, I've been teaching at the Pamantasan ng Lungsod na Maynila since 2017 in the College of Law and in the Graduate School of Law since 2017. Likewise, I've been teaching with the Polytechnic University of the Philippines and Universidad de Manila.
Okay. Sige. Can you just make a written explanation dito, ha? And
Yes,
to submit it within 5 days?
Yes, Your Honor.
Okay, sige. Now you are certified to be fit to work.
Yes,
I will no longer go into your credentials. They're impressive, no?
Opo.
Ito lang dito lang sa medical certificate.
Yes,
You
sir.
were certified fit to work, but then there's a notation for you to continue maintenance medications. What are these
These
medications?
are for
Maintenance.
my maintenance for my high blood, hypertension, low certain potassium. It's once a day,
Mm-hmm.
uh, 40 ml. And for my cholesterol, it's simvastatin, 20 mg per day.
20 mg. How about your chest X-ray, which shows cardiomegaly, atherosclerosis aorta, and thoracic spondylosis? Can you explain what these adverse findings are?
Yes, Your Honor. When I was in Court of Appeals, Cebu, I had my medical exams with a treadmill, and they find me fit to work. And up to this time, that I think that's the findings because maybe because of my age.
Okay, but this does this bother you
Doesn't bother me.
at all?
In fact, I do exercise once in the morning, and I do walking every day, 1 hour a day.
Regular exercise yan.
Yes, Your Honor, except Sunday.
Okay. In case it rains, where do you
I,
exercise?
yes, I exercise at home with the YouTube.
Okay.
I
Yung sa kwan,
Opo, sa Zumba and all the
Zumba.
exercises.
Oh, sige. Okay. Now, since your retirement justice, what made you you were rather I'll go first to the person who nominated you. You
Yes,
were nominated by Associate Justice of the Supreme Court, Jose Perez.
yes, Your Honor.
Okay, what made you decide to give your conformity to it?
Yes, because I think it's I invoke the presence of the Lord because
Mm.
for a long time I've been teaching with the MLQ. One day the secretary called me and says, Justice Manan, maybe you are most qualified to apply to the Legal Education Board because there is a notice for the application. And then I said, I might consider. So Justice Perez and I talked one time when, because he is the dean of the MLQ School of Law right now.
Mm. Ah, okay.
Yes, he's the dean of the MLQ School of Law. And I returned teaching immediately because he invited me to return to MLQ. So I returned and then he said, apply for this position. You are qualified because I know you since you were an MTC judge of San Pedro.
Okay. So, what keeps you busy since you
Right.
retired?
Yes, I am teaching 3 times a day, online teaching, and then I have to take care of my daughter who is going to have her medical board exam by March.
Okay, congratulations. Good luck.
Thank you po.
Una yung congratulations na.
Sana nga po, sir.
Okay, sige.
Salamat.
Now, should you ever be appointed as the LEB chairperson, what reforms do you have in mind that you want to initiate in order to better achieve the objectives of the Legal Education Board?
Yes, Your Honor. Number one, the reforms that I want to introduce to the Legal Education Board is the monitoring of all law schools in the Philippines if they comply with the physical plan, especially the library, the facilities, the faculty lounge, and the cleanliness and environmental sanitation now that we are facing the pandemic. That's one because I think physical plant plays an important role in the learning of the students because when you go to a room, to a classroom, or to a school where the environment is friendly and hygienic, it makes you feel uh, very, very interested in learning the law. And likewise, number two, since we are in the technology age, I want to introduce also that libraries should have computers and e-library for the students to make researches on the jurisprudence laid down by the Supreme Court, and likewise on the legislative act that is passed by Congress, so that they will know how laws are being enacted up to the time it is signed by the president. Number three, I want to have a law journal for all schools so that professors and students can participate in writing digest cases and also in writing their opinions about the jurisprudence laid down by the higher court of the land. Number four, the debate, and the debate should be very, very clear to the students. So there must be an inter-school debate so that the students will be used to language proficiency and also qualitative and quantitative reasoning. And likewise, number four, for the faculty members of the schools of law to have a regular seminar, maybe 6 months, every 6 months, so that they can have the modern trends of pedagogy, the teaching methods, and not to have an intimidating way of teaching the students, because that is the way how we were taught in the College of Law. I think my approach now is to show compassion to the students so that they can learn easily. Because if there is love and there is happiness, they go to school lighthearted and they learn fast in that way. So
You
those are
said,
some of the
yes, okay, go ahead.
yes, those are some of the reforms. But of course, these reforms has been very much in use or in practice in some law schools. But I think, I'm not mistaken, I think there are around 85 accredited law schools. Some schools are beyond the standards set by the LEB.
Justice, the Ateneo de Manila University requires their students before graduating to write a thesis.
Yes, sir.
And they are not called, the course there is called Juris Doctor.
Yes, sir.
Do you intend to make it mandatory for the other schools, or
Yes,
or have you thought of that?
Yes, I think thesis writing for the degree of Juris Doctor is laudable, because when students are still in their College of Law, they can already prepare and practice writing, legal writing. So much so that these legal writing skills are needed when they go to practice law, especially in the courts where pleadings are in use.
So one of the powers and functions of the board is to adopt a system of continuing legal education. What do you intend to do about that, considering that it conflicts with the mandatory continuing legal education initiated by the Supreme Court?
Yes, Your Honor. I think that function of the LEB to have to prescribe continuing mandatory legal education is an encroachment of the rule-making power of the Supreme Court under Article 8, Section 5, where the Supreme Court has the power to promulgate rules for the enforcement of constitutional rights, for the practice, pleading, and continuing legal education, likewise to give legal service to underprivileged. I think that is an encroachment on the rulemaking power of the Supreme Court. So if I will be given the opportunity to be the legal, I might have that repealed, that portion.
Okay. Now, do you see the use of social media platforms as an innovative tool for legal education?
Yes,
And
Your
if
Honor.
ever appointed as the chairperson, will you advocate for the use of it?
Yes, Your Honor. In these pandemic times, I've been teaching for 2 semesters and we are using social media. I think social media makes the learners think fast, quick, and they can research in an instant click of a finger in the computer. Likewise, the time is flexible time. They have flexibility of time rather than brave the traffic jams in going to schools and make researches in the library. They
Mhm.
can make use of their time right in the comfort of their home or in the comfort of their office where they have free time.
Just like we are, what we are doing now.
Yes, yes, Your Honor. And then before I am already 71. But when I learned the rudiments of technology, I want to become a tech savvy.
And did you?
Right now, Your Honor, I am.
Okay.
I am doing it right now without
Right now,
anybody. Yes,
with the execom interviewing you.
yes, yes.
Uh,
During our psychological testing, our test, and our interview for the
uh,
third time. This is technology at work. Technology at work.
okay, Justice. Aside from the performance of schools of law graduates in the bar examinations, what other yardstick can be used to measure the success of law schools in the Philippines?
Okay. Some of it is that there must be a bar, mock
Mm-hmm.
bar to be given before the students are made to take the bar examinations. And
Okay.
likewise, as I taught, I usually give quizzes because I tell students that bar examinations are written or computerized. So you have to practice writing and writing in your paper so that it will make you adapt when the bar examinations come. So mock bar should be given, and likewise constant giving of quizzes to students will definitely help them improve their writing and language proficiency and also their critical thinking.
I think in a few months or yeah, before the bar exams, there's a mock bar to be conducted.
Yes, yes, Your Honor, by Justice Leonen.
Yes,
Yes, Your
yes.
Honor.
Okay. Now, which would you prefer in the in the type of examinations to be given? The objective type of the essay one,
I am for mix, Your Honor. Mix.
mixed.
Yes, the objective and the essay. I
What
am for
percentages?
maybe 20% objective
Objective.
and 80% essay.
Okay. Because if it will be essay, we can actually gauge the proficiency of the examiner, the one to take the examinations,
Yes,
by the
Your,
way he answers the question
yes, Your
and the way
Honor.
he uses the grammar.
Yes, Your Honor.
Okay. So, Justice,
Yes, Your
the
Honor.
Supreme Court in 2019 ruled on the constitutionality of the Philippine Law School admission test, which was PhilSat,
Yes, Your
in
Honor.
Femtel versus Leb and Abayata versus Medialdia and Leb. What are your thoughts about the decision? Are you for it? Why or why not?
Yes. My thoughts for the decision, I think the academic freedom override.
What
Yes.
about academic
Uh,
freedom?
in the decision, they scrap the PhilSat for being restrictive,
Mhm,
exclusionary,
mhm.
and oppressive
Okay.
because it it does not give everybody the chance to choose her course of study or his course of study. Because under the Constitution, it said every person has the right to choose her course of study subject to fair, reasonable regulations of the state.
Okay.
So the LEB being an executive agency, which is only attached to the Department of Education for purposes of budgetary constraints and also for administrative support, I believe that PhilSat is to be given, but it should be compared likewise to the medical exam board when there is the percentile rank. Because in the medical exam board, even though you do not pass the medical exam board, there are schools, by the exercise of their academic freedom, they get the students who did not make it to the passing score, but there is that called percentile rank, meaning they are compared to other scores which are lower than the passing grade. So maybe, Your Honor, my stand is to have a comparison with the National Medical Admission Test on how to admit students, because this is an institutional academic freedom. So schools may admit them subject to discretionary admission, and later on, if they are found not to cope with the course study, they can be guided by the guidance counselor of the school and tell them how to make good of their course in law. Because I think some are failing, but later on, they are late bloomers. Late
Yeah.
bloomers, Your Honor.
Actually, in the field of practice, actual
Yeah.
practice, those who are so insofar as academics are concerned are better trial lawyers than in the top 10.
Yes, Your Honor, correct.
Yeah.
Correct. Very much correct.
Right here in Bacolod City, who are the better lawyers? They are the
Yes.
so lawyers. Those who
Yeah.
merely pass the bar. Yung
Yes.
tamang-tama lang.
Opo.
Oo.
Kasi po yung after the bar, yung strategies, you can get that through experience.
Yes,
Yes.
correct.
Opo.
Sige. Now let's veer away from the lab, but go straight to your SALN.
Opo.
Itong observation ko.
Opo.
In 2012,
Yes, Your Honor.
you had a net worth amounting to 2,841,000.
Yes, Your Honor. Sir.
But in a span of 1 year,
Yes, Your Honor.
in 2013, it ballooned to 22,419,000.
Yes, Your Honor.
Why? How did this happen?
My inheritances, I got them from my inheritances. Inheritance from my parents.
Okay.
Yes.
How many
and
children? How many siblings do you have?
I have 8.
8.
Yes, Your
Wow.
Honor.
And your parents must be that rich.
No, Your Honor. I got the other inheritances from the relatives of my deceased husband, because my deceased husband was the one who died late. So he inherited the property rights of the 2 other siblings, who was a doctor, and the other one is a businessman. So they both are single when they died. So it went to my
Sa
husband.
kanya napunta lahat.
Yes, opo. And then my husband died, so it went to my SALN.
Okay.
Opo.
Now, from 2013, it decreased to 7,953,500 in 2014.
Opo.
And again, in a span of 1 year, in 2015, it again increased to 12 million plus.
Yes, Your Honor.
Are you in business?
My husband was previously in business, real estate.
Okay.
Real estate po.
So he made money while
Yes, while he
engaged
was
in that kind of business.
while he was alive. Yes, Your Honor.
he was probably a top-notch broker because
No,
you speak of millions here.
no, the family, when I married him, I did not know that they have vast
Mm.
lands of lands,
Mhm.
and part of Hills Ayala Alabang is theirs before, portion of it.
Portion ng Ayala Alabang. Di ba mga
Ayala,
madrigal pa niyan dyan?
Ayala Hills po, Ayala Hills.
Yung
Alabang
Ayala
Hills,
Hills.
Alabang Hills.
Alabang Hills.
Yes.
Okay. Now, how do you know if you are doing a good job, Justice?
Yes, I am doing a good job. At the end of the day, I can sleep well, and I summarize what I have done for the day. I pray, and if I can sleep soundly, I knew that I had done a good job.
Now, should you get appointed, how do you see yourself leading the LEB, which is a totally different world from the Court of Appeals from where you came?
Yes, I know that the law schools are with all the bright people, bright people.
Mm.
I will try to coordinate, to consult. Consultation is number one. Before we issue LEB memorandums and circulars, there must be consultation with the deans of the schools, and also try to visit the schools every now and then to see what development or how can the LEB help them cope with the times, and also with the aim of uplifting the legal education in the Philippines.
Justice, you have been with the judiciary for quite some time.
Yes, Your Honor.
And considering that span of experience that you have in leading people, frankly and honestly, do you have the moral ascendancy to lead the LEB?
At this point in time, I will be trying my best to lead the LEB. Ascendancy, because I believe that Article 11, Section 1, that all public officials and employees must be accountable, serve with integrity, probity, independence, and must also practice patriotism.
Now, upon the other hand, do you have the required administrative knowledge and experience in the academic community?
Not necessarily, but Your Honor, I got my master in school administration and supervision at the University of the East in 1972. I passed the comprehensive exam, but unfortunately, I was not able to make my thesis because I was conceiving then and I delivered my first baby. So instead of having the thesis writing, I devoted my time to my first child to rear her, and now she's doing good.
And how did your subordinates and peers look up to you?
They look up to me as a strict
Mm-hmm.
one with work ethics,
Okay.
and one who is always punctual in everything that we do.
Okay. Okay. What is your philosophy of legal education, Justice?
Yes, my philosophy of legal education, let me define philosophy first, sir.
Uh-huh.
Philosophy comes from the two words. Philo means love, and sophos means wisdom. It's a love of wisdom. So it is it's my personal statement of how, as a mentor, will be imparting knowledge to students. My approach is a holistic one where the human dimensions like physical, mental, moral, spiritual, and cultural aspects of human dimensions are being honed by the mentor, not only the concepts of law, but also its application to real life. Because outside our profession, we are facing a life of the world.
Mhm. So between the Socratic method and case method or case method, which would you uh, prefer?
Prefer? Yes,
Uh,
Your Honor. I mix them. I mix them. So when I have the Socratic method, that's question and answer. Likewise, also discussions. The case method, in every discussion of each principle of law or each article in the book, I inject one case that is the jurisprudential pronouncement of the Supreme Court.
mhm.
So in that case, I make my syllabus according to article, and I let the students digest the cases in a composition notebook so that
Mhm.
they get to practice their writing skills, likewise their understanding of the law.
Okay. Now, would you encourage outcome-based education as a policy for legal education?
Partially, Your Honor. Outcome based,
Explain.
partially. Course, but of course, the concepts, the principles must be the basis. You
Mhm.
cannot have a good outcome if you do not have a full understanding and comprehension of the concepts, the basic principles of law, and the doctrines laid down by the law.
Now, let's go back to academic freedom. What do you
Yes, Your
mean
Honor.
by it? What do you mean by it?
Yes. Academic freedom is the right of teachers, students to study and teach, respectively, pursue a knowledge or research on a particular topic without unreasonable interference with the institutional's regulation, law, or public pressure. Academic freedom is likewise enunciated in the case of Oscar Pimentel versus Lev and Abayata versus Medialdia, when it says that there are four essential freedoms. One, who may teach, which pertains to the faculty selection and qualifications. Number two is what may be taught. It refers to the course of study, the subject matter, and the content of the curriculum. Number three is how shall it be taught? Now it refers to the method of teaching, pedagogy, pedagogical teachings. And number four, who may be admitted to study. It refers to the admission of students in a particular course of study.
Okay.
Those are enunciated, and I also saw that in other decisions of the United States Court on those four essential freedoms that include the academic freedom.
Are there parameters? And if so, what are its parameters?
The parameters on what may be taught, of course,
Yeah. Uh-huh.
yes, what may be taught, it must not be outside the content of the subject matter, or likewise, it must not be controversial. If it is controversial, it induces the feelings of the students because these students are very, very much active.
Idealistic.
Yes, idealistic, active. So the parameters are that don't inject controversial issues in a particular subject that you are teaching, meaning don't inject outside subject. So please maintain the subject matter and also how can it be taught or applied in real life situation. On who shall teach, it's also an academic freedom of the institution by having a standard of qualifications and compensation for each qualified professors or faculty members. Of course, each professor cannot have the professors cannot have the same salary. Yes, Your
Okay.
Honor. And who may be admitted, it's up for the school to have their prescribed format of like entrance tests, like essay writing, interviews, so that they can immediately gauge the potential of students. But of course, the last one is how shall it be taught? It must be within the content of the subject matter and not outside to induce or to evoke feelings of resentment.
Okay, Justice. Earlier, you mentioned some amendments that you would propose to Republic Act 7662.
Opo.
Are there some more of these amendments that you have in mind which you have forgotten, just missed to mention earlier?
Yes, the law internship practice, the law
Okay.
practice
Sige.
internship. Yes, I think that is a best example of one that is already in the lab functions and duties, that law internship practice will be monitored by the lab. Of course, I subscribe to that idea because it involves also private and public law offices, likewise legal assistance group, and also the courts where the students who have already attained second year law school can already have a practice internship, because it will expose them and orient them into the rudiments of legal work, especially legal writing, legal litigation, and legal ethics.
Okay. Okay, Justice. That was my last question.
Thank you po.
Thank you for your time and good luck.
Thank you, sir. Thank you.
Okay.
Thank you very much, Your Honor, Judge de Monteverde.
Thank you, Attorney Ann.
Honorable Justice Noel Jimenez Tiham will be the next to propound questions to Justice Manahan. Your Honor,
Thank
Justice
you,
Manahan.
Attorney Ann. Good afternoon.
Yes, good afternoon, Justice.
I know that you're very much qualified
Thank you.
to join to be chairperson of the Legal Education Board.
Thank you po. Thank you.
I was listening like a student to innovations and the reforms you wanted to introduce in the Legal Education Board. I was a little bit alarmed because you have a successful and a good experience in the Court of Appeals.
Yes, Your Honor.
You might be jumping into the fire. You go to the Legal Education Board in the event
Yes,
those
Your Honor.
reforms you wanted to introduce, they elicit lukewarm reception from law schools.
Yes.
As chairperson of the Legal Education Board, will you be imposing sanctions upon them?
Uh, you know, lawyers, lawyers are, I think, in the highest level of the courses. Lawyers is one of them, but through consultation, Your Honor, consultation and coordination, knowing their needs, coordination, consultation, and dialogue with them, maybe I can use my persuasive powers.
I know that you're persuasive and
Yeah.
convincing, but the recent decisions of the Supreme Court in Pimentel versus Legal Education Board sort of emasculated or diminished because there were certain restrictions made by the court insofar as the powers and authority of the Legal Education Board. Based on that decision, in layman's term, because this interview is broadcast to the public,
Yes, Your Honor.
what would be the extent of the power and the authority of the Legal Education Board? It's legal education, so it's essentially will govern law schools and law students.
Yes, Your Honor.
So when does the authority of the Legal Education Board commence, and when does it end? For
Yes,
better understanding by the public.
yes. A reading of the functions. I read the function that said number one is to administer the legal education in the Philippines. I think that word administration is improperly used because when you have a school administration, it involves number one, from the planning of the physical plant to the recruitment of to the recruitment and selection of the faculty members to having all the facilities to be conducive to the learning situation, likewise to the budgetary constraints from the time the school opens up to the end of the budget. That's administration. And that administration should not be given to the Legal Education Board. Number two is to supervise law schools. I believe that is one, because supervision means only overseeing what the schools are doing to have their objective fulfilled. So I subscribe to that supervision. Number three, to prescribe the minimum requirements for the accreditation of law schools. I also subscribe to that because being the Legal Education Board, that's the highest agency that oversees the legal education system. And to accredit law schools is also okay, but to prescribe curriculum is also okay. The curriculum is to be uniform in law schools because the bar examinations is uniform. So the curriculum must be aligned with the subjects to be asked in the bar. But of course, the one that was already asked by Honorable Monteverde about the mandatory continuing legal education, it is already an en banc resolution. It's a bar matter, that bar matter 850 that was already promulgated, I think, August 22, 2000. That supersedes the LEB because the LEB was only in 1993, but it became functional in 2009 after 16 years.
But in layman's term, you would agree with the proposition that the authority of the LEB will end once the law student graduates, passes the bar exams, and becomes a lawyer. Or rather, after graduation,
It's only there must be a demarcation. There must be a line between legal education and legal practice. So once the students are already in the law schools, by virtue of its functions and declaration of policies, will have a hand. But once the law passes the bar, it's now the Supreme Court through the rule-making power, because the rule-making power states rules on track of law, pleadings, and also admission to the bar. So there must be a demarcation line.
The Legal Education Board has also exercised certain rule-making power by issuing memorandum orders. in the past, correct?
Yes.
Now, we ask this of all applicants, the meaning of academic freedom. The Constitution does not seem to define what academic freedom is, correct?
Yes, Your Honor.
Simply says that academic freedom shall be accorded to institution of higher learnings.
Yes, Your Honor.
So the definition of academic freedom, was it because of a law passed by Congress, or was it because of jurisprudence
It's in
rendered
the
by the Supreme Court?
yes, it is in the Constitution, Your Honor. Academic freedom shall be enjoyed by all institutions of higher learning.
Yes, the term academic freedom is there, but the
Yes.
definition of academic
Yes. Yes, the definition is not there, so it is subject to all kinds of definition. And this academic freedom is also, there are three, I believe there are three kinds of academic freedom. One is academic freedom to be practiced by the institutions, those are the schools. Academic freedom to be practiced by the faculty members, and academic freedom to be practiced by the students. So those academic freedoms must be enjoyed.
event justice that there is a conflict in the
Yes,
exercise of academic freedom by the schools vis-a-vis the faculty and vis-a-vis the students.
yes.
Which do you think is paramount?
I think the paramount academic freedom is the institution, because when they have established their schools, they have their statement of vision and mission. And they also have their statement of policies, rules on discipline of students, rules also on discipline of faculty members and the non-teaching personnel. And everything has its own policies. So I believe it's the academic freedom of the institution that should prevail over faculty and student academic freedom.
When students are allowed by faculty members to cut classes so that they can participate in protests alleging legitimate grievances against the government, in your opinion, is that an exercise of academic freedom?
I believe so, Your Honor, because student activism is the work of students to cause political, economic, social, educational, environmental change. So they want to have it in an overt act so that the government will see that they really mean to have a change in the institution of all the policies, most specifically if it is a governmental policy.
Now, going back to academic freedom, we agreed that the Constitution does not define, but it is rather defined through jurisprudence rendered by the court, the Supreme Court, in many
Yes.
cases. Now, my question is, theoretically, should the Supreme Court define the word academic freedom, which is found in the Constitution? Should it not be Congress that should define academic freedom? Because if the Supreme Court does it through jurisprudence, is the Supreme Court resorting to judicial legislation?
Yes. I believe, Your Honor, it should be defined by the lawmakers, because the lawmakers were the ones who promulgated the Constitution, and there must be a broad definition of what academic freedom is. That's why we only see academic freedom as defined by jurisprudential pronouncement of the Supreme Court.
Now, the court, in the case of Pimentel versus Leb, which, by the way, is not yet final because there is a pending motion for reconsideration, struck down several issuances of the LEB uh, on legal apprenticeship and law practice as a requirement for taking the bar because it interferes with the court's rule-making power. But if the LEB merely mimics or restates a policy of the Supreme Court, is that basis to strike it down as unconstitutional, in your opinion?
In my opinion, since legal apprenticeship is a part of law course, the demarcation is there. It's a part of legal education. And legal education is under the supervision of the LEB, Legal Education Board. So after passing the bar, it's now the Supreme Court which has jurisdiction or which has supervision over the lawyers.
Now, the Supreme Court directed the adoption of online bar examinations this year, probably in November.
Yes,
Is that constitutional?
I believe it is because we are in a pandemic situation. This is an extraordinary times, and extraordinary measures should be undertaken so that the students will not be lagging behind their courses because it's already 1 year that we have suspended the bar examinations.
But
And
is that in
I
the Constitution?
believe, Your
Justice,
Honor,
is that in the Constitution that in
Uh,
case of pandemic, in case of pandemic,
Uh,
you
yes,
can
Your Honor.
take extraordinary measures? So what is
Yes, Your Honor, because
the constitutional basis?
it yes, it's not in the Constitution, but of course we can adapt to the changing times and not lag behind those students who are about to take the bar. I think
It's
it's just fair
is it the rule-making power, the
of the
rule-making power of the Supreme Court on admission to the bar? So that's
yes, Your Honor. Yes, it's a rule making power.
all right. Can the Supreme Court direct or dictate that classes in all law schools for law students be conducted online? Is that also constitutional?
I think it's the LEB's function, Your Honor, because
Not
school,
the Supreme Court.
not the Supreme Court, Your Honor.
So that would be unconstitutional.
Yes.
So you think that the LEB, in certain cases which may be justifiable, may allow physical presence in schools in some cases where it is feasible.
Yes, Your Honor. The LEB may do that because it's still under the ambit of legal education.
So do you think, so what is the extent of the influence of the Supreme Court on legal education?
I believe,
We're talking of legal education. We are talking of law students. We are not
No.
talking lawyers.
yes, the Supreme Court, as I said a while ago, there must be a demarcation. Once the students are still in law school, they must be under the supervision of the LEB because it is the legal education board, meaning legal education means it is the professional institution for students to cultivate and impart the knowledge of law so that they can be using it when they become lawyers. So there must be a demarcation, legal education, as long as they are studying law course, LEB should supervise. But once they pass the bar, it's now with the Supreme Court supervision.
Can the Supreme Court regulate and supervise legal education under the exercise of residual power? And what do you mean by residual power?
So residual power is the powers that are still in the hands of the Supreme Court before the LEB was created. So everything during that time was in the hands of the Supreme Court, the legal education system. But because of this creation of the Legal Education Board, the board must stick to the educational system of law schools. And after passing the bar examinations is the IBP together with the Supreme Court.
So what do you understand by residual? What remains? That is what you're
Yes, what
understanding.
remains in ours.
Residual power is a power which is not reposed with the legislative, it is not reposed with the executive, but which the judiciary thinks it can exercise uh, in relation to its mandated function. So your answer is the Supreme Court cannot do that.
Yes, Your Honor.
Does the Constitution allow or they prohibit members of the Supreme Court or of other courts to exercise, perform, and supervise other functions like legal education?
Performance supervised functions.
The function of people in the judiciary is to decide cases. That's a judicial, just to decide cases. Does the Constitution allow a member of the Supreme Court to exercise legal education, to perform and supervise other functions like legal education?
Your Honor, may I have the question because the connection is unstable.
Yes.
I was not able to
I
hear
noticed
your
that
question.
your face freezes from time to time.
Yes,
All right.
yes, yes, Your
Let me go to another point. The LEB is executive, correct?
yes, Your Honor.
Then why is it that under the law, Republic Act 7662, the Legal Education Reform Act, it delegated to the JBC the vetting, just like what we're doing. The vetting, a short list of nominees for the chairperson and members of the LEB, when our mandated function is to recommend appointees to the judiciary. Is this not a constitutional aberration?
I think not because, you know, when we talk of judiciary, we mean most peoples are lawyers. Those in the top positions are lawyers. So maybe the makers of the law that is authored by Senator Angara, who is a lawyer, deem it proper and necessary that the Supreme Court through the JBC will be the one to select, nominate, and recommend the LEB membership.
Is the JBC not violating the Constitution? Since we are vetting appointments to an executive body?
I think not, Your Honor, because I think no council can ever have a very, very in-depth interview of the candidates to determine the qualifications, except the
You're
JBC.
talking of practicalities,
Yes.
the expediency. But theoretically, can Congress, by law, assign that function to the JBC? Can they do that? The JBC is under the supervision of the Supreme Court. The JBC
Yes.
vets, interviews, evaluates appointments to the judiciary. Why suddenly Congress passed the law placing the vetting of members of the LEB to the JBC? Is that not against the Constitution?
I think it's against, it might as well be in the Commission of Appointments, Your Honor. Commission on Appointments.
Correct.
for us to be interviewed. But because the author is Senator Angara, who is a lawyer and a former dean of the UP College of Law, maybe he deemed it very necessary and very prudent to have the JBC interview the candidates.
All right. That's my last question,
Thank you.
Justice. I know you're qualified.
Thank you.
Thank you for your time and good luck.
Good. Thank you, sir. Thank you, Your Honor.
Thank you very much, Your Honor, Justice Tiham. To interview Justice Manahan next is Honorable Judge Toribio E. Ilaw Jr.
Yes, thank you, Attorney Ann. Yes, good afternoon, Justice.
That's Ilaw.
So, Justice, what's your complete name again?
Carmelita Salandanan Manahan po.
Carmelita Salandanan Manahan.
Opo.
And your husband is Manuel
Opo.
Manahan Jr.
Opo.
In relation to the late Senator Manny Manahan, contemporary of Malapus. Yes,
Yes,
any
sir. They are relatives. They are relatives.
relatives. Manuel Manahan Jr., your late husband's name,
Opo.
is junior.
Yes, Your Honor.
And who's that senior?
Yes, but the middle name Manuel Manahan Sr. was a doctor of medicine and an author of microbiology and pharmacology books of medicine.
Dr. Manahan
Opo.
of Manila Doctors Hospital,
Opo.
and whose wife was Elvira Manahan.
That's Makati Medical Center, Your Honor.
Before, it was Manila Doctors. Makati Med was not yet established then. So the wife of Dr. Manahan was Elvira Manahan.
No po. They are relatives. They are family of doctors. Antonio, Constantino po siya. Constantino Manahan. The husband of
Constantino. Yeah, the husband of Elvira. The husband of Elvira. Elvira of Two for the Road.
Yes, Your
Still
Honor.
remember her.
Yes, Your Honor. And the mother of Johnny Manahan.
Okay. Now, browsing over your records, you started likewise as a branch clerk of court, RTC, Branch 75, Valenzuela City. Justice?
Yes.
It
Yes,
was
Your
then
Honor.
presided by...
Opo. Yes, Your Honor.
It was then presided by...
Jaime Bautista.
Jaime Bautista.
Jaime
Yes, Jaime Bautista. What did you learn from your presiding judge then? Leah, you're having a problem?
Justice Manahan.
Yes, I'm now on. Hello.
Yes, Justice. Can you hear me?
Opo. Yes, now Your Honor. I can hear you.
Judge, permission to address the glitch lang po.
Yes, sir.
Okay, thank you.
Justice Manahan, Dennis, can we put on spotlight mode?
Yes.
Justice,
Opo.
are you using Wi-Fi po? Second
Yes.
device, please. Secondary device. Can we switch to your second device, Justice? Can you turn to your other device po? This one, yes.
Yes.
Okay.
Yes, yes. Yes, sir.
Can you hear me, Justice?
Yes, I'm here now.
Okay, Justice. Pwede pong
Opo.
pakipatong lang sa more stable na you can put it on top of the table. Justice, your secondary device.
Yes, I'm here. Can you see me?
Yes, Justice. Nakikita po namin kayo. Your Honor, Judge Ilaw, okay na po.
Sorry. Okay. So my question was, what did you learn from the presiding judge, Jaime Bautista then?
Yes, Your Honor. Jaime Bautista, I just stayed. Hello.
Yes, sir, please.
I just stayed in his court for almost a year and 3 months because I cannot work with a judge who is not credible and who has no integrity. Sorry to say that.
Is he still around, Jaime
No,
Bautista?
he died already, Your Honor. He is the one from San Beda graduate. He is only about when he is about when I left the branch 75 after several months, he was entrapped by the NBI and had his case in the Sandigan Bayan. He was, I think, convicted, but because of the conviction, he got sick and he died.
Poor guy.
He's relatively a young judge coming from Angono, Rizal.
Yes, I knew him because he was a junior to us in Sambeda. Sorry to mention our school to be dragged on such alleged scandal. At any
Yes,
rate,
I'm sorry, I'm sorry to say that, but I am very, very honest of what happened.
okay. So you already retired. When was your retirement?
March 22, 2019, 1 year and 10 months ago.
And why do you wish to come out of retirement and chair the Legal Education Board, Justice?
Yes, I love teaching very much. And 4 of us, brothers and sisters, are all in education. I love teaching very much. That's my pre-law degree.
You've been asked or had some clarifications about your SAL and Justice.
Yes, Your Honor.
Now, could you explain the huge discrepancy in the amount of cash deposits, referring to the cash deposits as stated in your 2019 SAL and in your PDS, around 4 million in SAL and as of
Honor, I got my retirement in 2019, and I put that in the bank, and it earned interest.
All right. Likewise, in your 2019 SAL end, you declared that your son, Michael John Manahan, is an executive assistant. Executive Assistant 6.
Opo.
In your PDS, which was received by this council on July 29, 2019, you stated that he is self-employed, while in your updated PDS, he's now a caregiver in the United States.
Yes, Your Honor.
Could you briefly explain these changes?
Yes, he was my executive assistant in the Court of Appeals in the retirement, up to my retirement on March 22, 2019. Thereafter, he already had a small business of buy and sell, and later on October 2019, he went to America and worked as a caregiver.
When asked by my colleagues, do you consider yourself physically healthy? Do you consider yourself physically healthy? You're taking medications as your maintenance?
Yes, Your Honor. It's on a controlled level.
Justice, what is course-based integration and course substitution under Legal Education Board Memorandum Order number 23, which was approved on December 21, 2020?
Course-based integration.
Yes, course-based integration and course substitution.
In my understanding, course-based integration is that you integrate the students taking law will integrate in their law practicum what they have learned in the study of law in the school. And course substitution, maybe it's a form of a paralegal work that they can indulge into whenever they have already graduated from law school.
All right. Do you think the Legal Education Board adds value to the legal education?
Yes, Your Honor, because that is a supervising agency so that the legal education will be uplifting its program. Because the reason why RA 7662 was legislated by former Senator Angara is that there are very, very few law students or law bar examinees who pass the bar yearly. It ranges only from 16% to 21 or 22%. So Senator Angara authored this Republic Act 7662 in order to have the upliftment of the legal education program to keep it with the times.
All right. Thank you. All right. At present, the United States Supreme Court decided to hear a case involving a case of student speech. The issue is whether the school may discipline the act of a high school cheerleader who published a profane social media post while out of school and on her own time. Do you think that school administrators may regulate the speech of their students? This case is BI versus Mahanoy Area School District.
Yes, Your Honor. This school may have the authority to have that students called or to ask him to refrain from publishing materials that are not within the school's mission and vision, because I think it's an institutional freedom that all schools of learning has the right to gear their education towards the holistic approach of the individual and not for any profane publication that is being published by any student.
Do you think that law schools greatly contribute to a student's identity?
Very much, Your Honor.
Why do you
Very
say
much.
very much? Why do you say it's
Very much,
very
Your
much?
Honor, because in the Philippines, we have the publication of the top ranking law schools. So if you are a graduate of the top 10 law schools, it bears an identity to the lawyer. And of course, we are aware that these top law schools are very much in keeping with the trends of the time, and also in choosing and selecting the faculty members who will teach the law.
There is a suggestion of removing publishing top-notchers in the bar examinations. What's your view on this?
I believe that publication of top notchers will serve as an encouragement to other students who will study the law or other courses, because when you see top notchers, they are encouraged to do the same, especially when they are asked about their experience, about what methods did they use, and what are the time management did they have their schedule in studying, also in the physical development of their mental faculties. I think that is an encouragement and motivation on the part of the students who want to follow suit the law course or any course that they want to have in the future.
Do you think we have an oversupply of lawyers, Justice?
I think none, Your Honor. We have no oversupply of lawyers because right now I think the lawyers roster is only up to 67,000 or 68,000 lawyers in the entire Philippines, and we have at least 111 million Filipinos. So the proportion, the percentage is so much very, very small. And we need lawyers to become leaders.
There's no such oversupply of lawyers, but when I was in private practice that in early 70s, I was then appearing before the CFI judge uh, Pardo.
Opo.
Pardo, and a litigant was asked, "Where is your lawyer?" The litigant answered, "I have no lawyer," because at that time there was only CLAO, Citizen Legal Assistance Office. And lawyers are being discouraged to sit at the lawyer's table, apprehensive of being appointed as counsel de officio. So when asked, "Where is your lawyer?" the litigant said, "I didn't have a lawyer." Judge Pardo said, "You mean to say that if you're just going to spit out of the window, ang tatamaan daw ay lawyer?" Is that Judge Pardo, that then the CFI at the Caloocan ng ano. So do you think there's no oversupply of lawyers? Maybe oversupply of not good lawyers. So many notary publics.
Yes, but the notary publics are not the ones notarizing. It's their aid.
Alright, why new justice? In 2017 or 2018, the JBC had really a problem of filling up vacancies in the Legal Education Board, respect to the positions of chairperson, regular members of the LEV, representing the active practitioners sa law schools ng the dean, that we had really to reopen and to reopen. That's the reason why we were constrained to, and such a problem was addressed to then Congressman Umali, was then either for the abolition of the LEV or the reduction of the members of the LEV.
Yes.
And it was, but it was overrun, what overrun by this case of Pimentel versus LEV. So in my observation, there are so many questions and so many answers with respect to the decision of the court. In fact, even the court was divided in its decision. So many questions, so many answers. And even the current, mind you, current Chief Justice did not take part.
Yes.
Moreover, the province of Congress is to make and repeal laws, while the judiciary to interpret laws. In fact, on March 10, 2020, the regular members sent a letter to Congressman Veloso representing Congress. The problem of the JBC in filling vacancies for the LEB. In that letter, the members requested Congress to aid the JBC by abolishing the Legal Education Board and creating an office under the Supreme Court with similar functions, taking into consideration the functions which were declared unconstitutional by the court pursuant to Section 5, subparagraph 5, Article 8 of the Constitution.
Yes, sir.
Your opinion or your view? It's not
Yes, as I read the Republic Act 7662, I saw I think three functions that should not be included in the LEB, but instead in the Supreme Court, like the mandatory continuing legal education, the administration of the law schools, and also the law practice internship. Because the law practice internship, they go to the courts, they go to public, private law offices where they have their practicum. So these courts are under the supervision of the judiciary, the Supreme Court. So they are encroachment on those rule-making power of the Supreme Court. So in other words, I can see only number one, the supervision of the legal education, accreditation of law schools, setting the minimum standards for the accreditation, likewise also the facilities of the schools as to the size of enrollment, as to the prescription of the curriculum. I think those are within the ambit of legal education. The rest, the three of them, I think are with the rulemaking power of the Supreme Court. And also,
Right.
Justice, I subscribe that if the Legal Education Board will be under the Supreme Court, it will be much better and much more effective supervision of law schools if it is under the Supreme Court.
We have in mind of abolishing the Legal Education Board and shall be replaced by the Legal Education Office, which shall be under the Supreme Court, considering the inevitable relationship of legal education, admission to the bar, and the practice of law.
Yes.
The Legal Education Office shall have general jurisdiction and control over all matters relating to legal education and shall supervise, regulate, and exercise of its powers in accordance with the provisions of the law and the supervision of the Supreme Court. Do I get
Yes.
that you subscribe to the view of
I agree to that. I agree to that proposition because to make everything whole, all legal education system, likewise its practice must be under the one office, and it is within the judiciary.
because honestly, this representation is the proponent of this while asking Congress to pass a law.
Yes, sir.
And also, or the reduction of the number of the legal education members of the board and taking other measures such as having the representatives of the IBP and the Philippine Association of Law Schools serve in an ex officio capacity who will therefore automatically serve without undergoing the selection process of the JBC. And second, removing the preference of the Supreme Court and the Court of Appeals justices to chair the Legal Education Board to encourage more applicants.
Applicants, correct. I subscribe to that, Your
Okay,
Honor.
correct.
I subscribe to your proposal.
And number 3, reducing the required teaching experience from 10 years to 5 years to qualify and encourage more applicants.
Yes, Your Honor.
What's your opinion?
Yes, Your Honor.
You
I
also subscribe to such proposal.
Yes, to your proposal.
And lastly, other measures that would empower the Legal Education Board without impinging on constitutional freedoms and thereby encourage more applicants and improve the legal education's structure and systems. I know there will be a lot of calculating documents considering the sensitivity of this issue, so that all questions may be answered through the amendment of the Legal Education Act.
Okay. I subscribe to your proposal, Your Honor. I subscribe to it.
I'm not
There's a provision.
because I'm not discouraging applicants now to the Legal Education Board. It's just a matter of abolishing it and replacing it by a legal education office, this time under the supervision of the Supreme Court.
Okay. Yes, Your Honor. I subscribe to that proposal.
All right, Justice, my time is off. And my last question, please.
Yes, Your Honor.
A man builds a house in rectangular shape. All sides have a southern exposure. A big bear walks by. What color is the bear?
Big Bear, it's color white.
Why?
Because bear is white. Most bears are white.
No, their bears are color brown.
Some bears, but most of them are white and brown.
You're correct. The house is at the North Pole. So it is a polar bear. Thank you. Thank you. That made you laugh. And just to lighten.
Oh my
Di po
God.
ba? Tama.
Yes, you made
Tama
my
po,
day.
Justice.
Thank you for that joke.
Thank you, thank you. And again, good luck.
Thank you po, sir. Thank you.
Thank you so much, Your Honor, Judge Ilaw. The last to interview you, Justice Manahan, is our Executive Committee Chairperson, Honorable Justice Jose Catral Mendoza.
Yes.
Your Honor, Justice Mendoza.
Thank you very much, Anne.
Yes.
Good afternoon, Justice Manahan.
Yes po. Good afternoon, sir.
I have heard your answers to the questions of my colleagues, and I also reviewed your records, and
Yes,
they are
sir.
very impressive.
Thank you.
You really took education, and you're from Binyang, and my eyes was focused on Santa Cruz where you took the exam. I was assigned there for 5 years.
Yes, I
I
know. I know,
assigned
Your
there for
Honor.
5 years. Oh,
Yes, I know. RTC,
yes,
Santa Cruz,
yes,
Laguna.
yes. One of your references or one supervisor you mentioned sa Judge Stella Cabuco, Andres Cabuco. How is she?
Yes, Your Honor. Yes.
How is she now?
I,
You were
I,
together in Laguna. You were together in
we
Laguna.
were, she was the executive judge then of San
Yes.
Pedro, Laguna.
Yes, oo.
But she
Together,
retired
you were
early.
together with Minita. Sorry, Justice Minita.
Tario, yes. Opo, opo.
Oh. Anyway, I just have a few questions. Are you aware of the case of Tablarin versus Gutierrez?
I am not, Your Honor. Honestly, I am not aware of it.
It was a case where the NMAT was declared constitutional, National Medical Admission Test.
Yes, opo.
However, the PhilSat, which covered law students or law schools, was declared unconstitutional. Uh, you have not read the NMAT case, but you have read the Pimentel case.
Yes, yes, Your Honor. I read the Pimentel
Oh,
case.
in the Pimentel case, uh, there were at least three reasons why PhilSat is different from NMAT.
Yes.
Do you remember the reasons
Yes,
in
I
that decision?
remember. Yes, I remember, Your Honor, the three distinction between
Yes,
the PhilSat and the
NMAT.
NMAT. In the PhilSat, the LEV had fixed a score of passing rate of I think 45%
Yes.
total score of passing rate. Whereas in the NMAT, it's on a percentile rank, meaning your score, the score of a student who take the entrance exam in the NMAT is compared to other students which has a lower and a higher score. Second, in the NMAT, some schools are at liberty to accept those who do not make it to the best scores like 55, and they are at liberty because they invoke their institutional academic freedom of accepting students that had a low grade in the NMAT, whereas in the lab it's sweeping, meaning if you don't pass the passing score of 45%, you cannot enroll. And those schools that will admit those fail those who fail, the flunkers, will be sanctioned. But on the other hand, they said the LEB said they can be admitted on a discretionary admission, meaning they have to come up with good grades within the semester, and that will be reported to the LEB.
So, uh, uh, you really read the Pimentel case, but you just could not remember the Tablaring case, which you recited. Anyway,
Yes, yes,
and
yes.
anyway, the Pimentel case is not yet final. There are pending. There are several pending motions for reconsideration. The ponente has already retired, so
Yes.
it's still there hanging. So, have you read the Pimentel case entirely?
Yes, Your Honor, once. Yes, I think
Uh,
there are two petitions, consolidated petitions in
yes,
this
yes.
case. Yes.
Anyway,
And
you have read the. We'll go to just the dispositive. You remember the dispositive portion of the
yes,
Pimentel case?
they struck out lab memo number 7 that is requiring the law students who want to enroll to have the PhilSat passed because
Yes.
it is an encroachment of academic freedom on the institution on who to admit to the study of law.
Anyway,
So likewise,
two two uh, two provisions were deemed constitutional. What are they? They were ruled as constitutional, declared as constitutional.
Two provisions that were declared
No,
unconstitutional.
No, constitutional.
Constitutional.
Yes.
That's the
Two sections
yes.
of Republic Act 7662. What were those declared constitutional?
The two provisions that were declared constitutional
Yes.
by the LEB is the academic freedom of the institution to admit students in the law course.
With respect to admissions, what else? Power to set standards or accreditation for law schools. One,
Yes, and the power to set
power
the
to
standards.
prescribe minimum requirements for admission to legal
Opo.
education, yan, and minimum qualifications without encroaching upon the academic freedom of institutions of higher learning. What were declared as constitutional?
Unconstitutional, Your Honor.
Yes.
What is declared unconstitutional is the
Four.
requirement
There were four provisions, four sections. Do you remember them? Only those you can remember.
unconstitutional.
Yes, there are
Unconstitutional.
four
Number
provisions.
number one, the requirement of the PhilSat before a law student can be admitted to law school, because it is an encroachment of academic freedom of the institution on who to admit to study law.
Yes.
Number two is the practice or law internship, law apprenticeship practice, which
Yes.
is already in the power of the Supreme Court. And number three is the continuing mandatory legal education, which is a bar matter, that is bar matter 850, which was an en banc resolution issued by the Supreme Court on August 22, 2000. So those are the three unconstitutional functions of the LEB.
Yes. Also declared as unconstitutional for being ultra vires is the act and practice of the LEB of dictating the policies on the establishment of legal and legal internship programs in violation of institutional academic freedom. Okay, do you remember that portion?
Yes, Your Honor, that's the law practice.
Yes.
It's unconstitutional
Recently,
infringement.
the LEB came out with memorandum number 23, series of 2020, so this year only, prescribing guidelines for the integration of clinical legal education in the basic law curriculum. What can you say about this?
Yeah, the practice of law apprenticeship program entails the commitment and the coordination with courts, law offices, private or government, legal office, which is already constituting the practice of law and not anymore legal education. So under the
So you do
rulemaking
not
power,
agree you do not agree with this memorandum order number 23?
I do not subscribe to that, Your Honor, because I think it's an infringement of Section 5 of the rulemaking power of the Supreme Court in matters of practice, admission to the bar, because law apprenticeship program is a quasi practice in law.
Okay. This case is not yet final because there are several motions for reconsideration. So I'm asking your personal opinion. Do you fully agree with this decision, or you want to reconsider some? Anyway, it's not yet final. You can give your own opinion, and I will not be taken against you.
Yes, Your Honor. I do not agree with the declaration that the PhilSat is unconstitutional because I think all courses of study in all institutions of higher learning, they have their prescribed admission standards of students. They require admission tests to be passed by students so that at the earliest opportunity, the potentials and the aptitude of the students can be gauged. However, on the other hand, as I said before, there are late bloomers, which they bloom late because of experience that they got from the practice of their profession. But as a measure to have a good study of any course or profession, I believe entrance test is a must. Only in matters of scoring will it differ. Like the NMAT, it should have been in a percentile rank rather in a percentage rank.
So your view is that the PhilSat should be declared constitutional, subject to certain restrictions,
Yes, Your Honor.
as long as they do not violate the school's academic freedom.
Freedom. Correct, Your Honor.
Correct. Correct. In Pimentel versus Leb, it was stated that the state, in the exercise of its reasonable supervision and regulation of education, can only impose minimum requirements.
Yes.
In your view, what are these minimum regulations or requirements?
Okay. One is number one, the minimum qualifications for faculty members is one. Qualifications of faculty members, and also the compensation to be given to the faculty members. Number two is the minimum requirements in the physical plant of the school, which should be very conducive to learning and very much attractive to students to study law course. And number three, of course, is the supervision of the LEV over law schools because as we know, there are so many law schools all around the Philippines that do not meet the standards of a good physical setup. The environment, the library facilities, the school itself, the classroom should be very much conducive to learning. So I think these are the functions, and these are also supervisory in nature and not administrative. The administrative functions goes to the institutions of higher learning, but not supervision is the agency because it's in the exercise of the police power of the government to supervise all schools of higher learning. That's why we have the Commission on Higher Education, otherwise known as the CHED.
Thank you very much, Justice.
Yes, Your Honor.
Those are only my only questions for you. You have
Of
answered a lot earlier.
Thank you po.
And I know you're knowledgeable about education.
Thank you, sir.
Okay. You are excused, Justice.
Yes, thank you, sir.
Thank you very much, Your Honor, Justice Mendoza. That brings to a close the public panel interview of former Court of Appeals Justice Carmelita S. Manahan. Justice Manahan, thank you very much. We wish you the
Thank
best
you.
of luck.
Thank you very much. Can I leave now?
Yes, po, Your Honor.
Thank you.
Your Honors, the last but certainly not the least candidate to be interviewed today is Professor Ana Marie Melanie B. Trinidad of the Sunkuya Trinidad Law Offices. She is a contender for the positions of Legal Education Board Chairperson and led regular member representing the IBT. Good afternoon, Professor Trinidad. Honorable Judge Franklin J. de Monteverde will have the first crack at interviewing you. Your Honor, Judge de Monteverde.
Okay, thank you, Attorney Ann.
Welcome, Your Honor.
Attorney Ana Marie Melanie Trinidad.
Good afternoon, Your Honor.
Yeah, good afternoon. Okay. You are a partner of the Parulan Songkuya Trinidad Law Office.
Yes, Your Honor.
Okay. And for how many years have you been a partner of such a law firm?
Sorry, Your Honor, I didn't get the first part of the question.
For how long have you been with the law office?
I've been with the law office for almost 20 years, Your Honor.
20 years. And in those years, during those years, what specifically were you working?
I do a lot of pleadings. I like writing. I would sometimes appear in court, but very, very seldom, Your Honor.
Did you actually teach law in law schools?
Yes, I'm currently teaching law. I've been teaching law for 12 years.
Where?
In San Beda College, Alabang. I've also taught in Mendiola, but only for a year. It was just not logistically feasible for me.
Okay. Let's go to your medical record. You were physically, psychologically, and overall medically fit to perform your duty. Who issued this medical certificate?
It was issued in what you call that, Veterans Hospital, Your Honor. The public medical certificate was issued there.
Okay, you were physically, psychological, and overall medically fit, but there had been adverse findings. And do you know what those adverse findings were and or are?
Not yet, Your Honor.
You have not gone over your medical record?
On my medical records, yes, but the psychological, not yet, Your Honor.
Not yet. So, kindly explain to us your complete blood count on hemoglobin, hematocrit, RBC, which are high.
My physician told me that that would have something to do with fatty liver. Fatty liver is connected to the blood, particularly the RBC, and that's why since
Is this the red blood corpuscle?
Yes, Your
The
Honor.
RBC? Okay.
Yes. Because if you have fatty liver, the liver excretes more bilirubin than necessary, and the bilirubin wipes out or throws away your RBC.
So how about your SGPT? Are they okay?
I can't remember anymore, Your Honor. I can't remember that one.
Okay. On urinalysis, you have a glucose +4. How is that?
I am diabetic, Your Honor, and that's why I have glucose deficiency. But since the pandemic, I've taken charge of that. I've embarked on a rigorous weight loss program, and that has helped bring down my glucose count and my increase or improve my insulin levels, Your Honor.
So how high is your sugar level?
Very, very normal. I used to take insulin twice a day. I've completely stopped taking insulin shots. My dosages of my capsules, the tablets I take, have been removed, if not very much decreased, Your Honor.
How many years have you been a diabetic?
Since I was 40 years old.
40. And
yes.
You are now 55.
I'm now 55.
Okay.
And it's only recently, about a year, not really, just really recently since the pandemic struck, that I've decided to take charge of that, and I've been quite successful.
But you're still taking insulin shots?
No more, Your Honor, completely gone.
Yeah? How did you do?
I've lost 30
You
pounds.
teach me because I'm a diabetic and I take insulin shots.
Your Honor, I educated myself on the dangers of insulin. It says there that the more you take insulin, the more your sugar glucose is just hidden in your liver. So you think it's getting low, but it's not. So that's why when you take insulin, you don't realize that every year your insulin dosages increase, which is what had been happening to me prior to my weight loss. So I just got heavier and heavier and more insulin dependent. So one day I just quit cold turkey. I just threw away my insulin, and every time my sugar level was high, I would just walk, or I did Zumba a lot.
Okay, so how long were you taking insulin? How
Since
many years?
since I took insulin for 9 years, Your Honor.
9 years. Huh?
Yes, I did.
Okay. Now going to your uric acid, group cholesterol, also high. And
Well,
then on your electrocardiogram, non-specific ST-T wave changes. What is this?
my doctor told me that if you have deficiency in your endocrinology system, it has comorbidities, and one of which would be your, of course, your heart. But if you sufficiently or increase, I mean, if you significantly reduce your sugar level, everything else would follow. And I suppose that's what's happened to me since.
So are you sure that you are medically fit to perform your job?
I'm absolutely sure, Your Honor.
Okay. Now, is this your first time to be interviewed by the JBC?
Yes, Your Honor. It's my very first time.
Okay. And how did you prepare for this interview?
I read on decisions pertaining to the LEB. I read a little about constitutional issues because I haven't touched a constitutional book in a long time. So I tried to read, but I could only read so much, though.
Okay. Now, you are 55 years old.
Yes, Your Honor.
And still single.
Yes, Your Honor.
But in your PDS, you wrote under the column, you wrote a name under the column children. Kindly explain.
I am a single parent. My daughter is 24 years old.
How old is she? 24?
She's 24, Your Honor.
You're that old?
Yes. I would suppose so, yes. Although I didn't, I gave birth quite late, though.
Okay.
But
now, according also to your PDS, you finished your college education, which was industrial engineering, for a period of 8 years, from 1982 to 1990. And aside from that, you also finished your law school for a period of 6 years, from 1993 to 1999. What took you so long to finish these courses?
Oh, to be honest, in my pre-law course, I didn't think I would take law. I thought I would just finish my engineering course. So I really didn't see the hurry to do that, although I regret that now. With respect to law school, I had to stop for a year because I gave birth. And after stopping for a year, I had to reduce my load units until I've completed all of them. I could complete all of them.
You took up your high school at the St. Paul's University, Tirang?
Yes,
Pedro
Your
Hill?
Honor. Yes,
Okay.
Your Honor.
And your elementary, St. Paul's College also, but in Parañaque.
Yes, Your Honor.
Okay. Also in your PDS, how come you did not put any data on the relevant trainings and other credentials?
Oh, my relevant trainings would be the ones in school and in the law office. I am presently taking my master's in law in San Beda. I don't think maybe I forgot to write about that, but that's what I'm taking now.
Okay, you have been
As
with
an added
the
credential.
okay, you have been with the law firm as a partner for 18 years now. How big is this firm?
Yes, Your Honor. Oh, it's we are 3 partners. We used to have 2 associates, but now we only have 1, and this would be on a project basis. That's because personally me, I like to handle my own accounts. I like to write all my pleadings. And so our associate does a lot of the hearing for us. And so do the other partners, Your Honor.
And what kind of cases are you handling there?
I've handled a few criminal cases. Very recently, I'm handling a rape case.
Only a rape case?
No, I've handled falsification cases
Okay.
and a few, very, very few civil cases.
So you are now the Vice Dean of San Beda Alabang School of Law.
Yes, Your Honor.
This is located inside Ayala, Alabang.
Inside Alabang Hills, Your Honor.
Alabang Hills. Okay. What kind of programs or projects have you spearheaded for the school during your stint as Vice Dean?
I for about a year or more, I think 2 years, I was the head of the legal clinic. And aside from that, as Vice Dean, I would help draft policies for the school. It's very much towards policy making, Your Honor. Of course, subject to the approval of the Dean.
Okay. Republic Act 7662 is known as the Legal Education Reform Act. So should you ever be appointed chair or a member representing the IBP, what reforms do you want to initiate in order to achieve better the objectives of the Legal Education Board?
Well, I think I would ask every law school to be prompt in submitting the repertorial requirements, the number of enrollees, and that way I would know whether the number of faculty in relation to the number of students is ideal. I would also embark on asking deans or law deans, law officials, to make sure that the legal education includes experience outside the law school, because I think that's also as important as learning the concepts of law inside the law school, Your Honor.
Now, how about this Socratic method of teaching in law schools? Is it practical today? Why or why not?
I think it is still practical in the sense that it allows or it trains the student to think on his or her feet, which would be very, very important in case he or she decides to go into serious litigation. And also, I think the Socratic method is a good test of, it's a good way of knowing whether the student has mastered the lesson for the day, the lessons or the laws which have to be mastered for the day, and of course for a long time after that.
And other than this method, what can you suggest as another one of teaching that is applicable in law schools or that could be applied in law schools?
I think what is what is missing in law school is a practical experience of the practical application of the law. Usually it is included in the fourth year subjects as part of the fourth year subjects. But I think this should be included in the first, second, third year subjects. And so there should be a time when the students can relate in class, which should be a bazaar of ideas for everybody, who relate his or her experience outside the classroom. That means observing what happens in court, or being part of a law office, not really being part, but really also observing what goes on in a law office, what goes on in administrative agencies. I think that should be included in the curriculum every year, not just in the fourth year, Your Honor.
So what kind of a leader are you, attorney? One that is a leader by example, or one that is somewhat participatory type?
I am a leader by example. I practice what I teach. I also am a very, very kind professor, but that's not to mean that I am lenient. I am participatory also in the sense that when a student is not doing very well in class, I go out of my way to ask what the matter is. And in that sense, I participate in their journey in the accomplishment of or in the obtainment of a law degree, Your Honor.
Okay. Being the chairperson of the Legal Education Board, you will be dealing with people, not only with the members of the board, but also with other stakeholders such as the Philippine Association of Law Schools, the active lawyers, and others, as well as some agencies in the government. So, under that setup, do you have the necessary moral ascendancy and authority, as well as the administrative and academic experience to be the next LEB chair for a
With
term of
respect to
5 years? Okay. Sige,
with
go ahead.
respect to moral with respect to moral ascendancy, I am definitely sure I possess that. Number one, I haven't been charged administratively or criminally with anything in my entire life. Well, that's not to say that there are instances that I do something that haven't been discovered. In truth, in my personal and in my professional life, I have lived morally, if I may just use that word. With respect to academic, I would say that I also have enough academic capacities. I graduated from the School of Law with a good ranking, not necessarily top 10, but I was in the top 20 of the class. I continue to update myself with jurisprudence, and specifically in the field, in my chosen field of expertise as a professor. And the other one, administratively, yes, my experience as a vice dean would certainly help me. I've been a vice dean for 3 terms. I'm going on my 3rd term. And I'm certain that even if I'm sure that my experience as such, having the peculiar role of being the conduit between the dean and the professors on one hand, and the professors between the professors and the students on another hand, I have the peculiar and the fortunate task of knowing the issues that befall almost every facet of law school.
So, what will be your first program or move for the Legal Education Board?
If I'm elected chairman, my first program would be to make sure that the schools which have been given accreditation still possess the necessary requisites in order to have that accreditation. And so I will go back to repertorial and see if every law school is doing its job, the officials of each law school are doing their job. And that is the way I could execute or perform my role, or the LEB's role, as an administrative and regulatory body over law schools.
Okay, Attorney Trinidad, what is your philosophy of legal education?
Oh, legal education has to be appropriate, it has to be relevant, and it has to be excellent in order that the student in order that the school would meet the needs and the aspirations of the student. And it should be, I mean, if there's anybody who wants to take up law but does not have the economic opportunity to do that, I think legal education programs should be available to those who are also economically disadvantaged, based on merit, of course. So just like education, it should be quality education, and it should be one that's accessible, of course, by merit to those who deserve it.
As a policy for legal education, would you encourage the outcome-based education?
outcome-based education. May I ask what you mean by that, Your Honor?
Well, I'm asking you.
Okay. I would say, okay, when if it's an outcome, if I should, well, I think results say a lot about what's going on inside a school. If they're doing well in the bar exam, that only means that they're doing something right in that school. So I would agree that outcome-based method of ascertaining the status of a school or the right of a school to continue with its operations is ideal and very, very necessary, Your Honor.
In short, this is like responding to what does a law student want to be, whether he wants to be a member of the judiciary, a prosecutor or defender, or a practitioner.
Oh, yes, Your Honor.
Yeah, ganun yan. Okay. Again, assuming that you will be appointed, what amendments do you propose to introduce?
Oh, as an LEB chairman, I would be very careful first to observe the academic freedom of institutions. So with respect to amendments, I would only make sure that the amendments would not curtail the right of a student to teach, the right of a professor to teach, and the manner by which he or she would like to teach. So my amendments would only be limited to supervisory, would not be intended to control the manner by which the school handles its businesses and affairs.
Okay, one of the powers of the board is to adopt a system for continuing legal education.
Yes, Your Honor.
Do you propose to continue with this or to revoke this as a provision, considering that we have the mandatory continuing legal education?
Thank you, Your Honor. I would, the Supreme Court has declared that that provision of the with respect to legal education board is unconstitutional, and I would agree completely with that because the purpose and the objective of the legal education board really is to improve the quality of education, and not only that, the legal, what you call that, legal, what was I saying? Your Honor, the question was, may I hear it again, Your Honor? Just the bulk of the question.
Yung Kwan, one of the powers of the board is to adopt a system for continuing legal education. This seems to be in conflict with the mandatory continuing legal education of the Supreme Court. What can you say about this?
Thank you, Your Honor. I would agree completely that this is an unconstitutional provision because mandatory continuing legal education is already being undergone or undertaken by lawyers as part of the requirements or as part of the policy of the Supreme Court. So that saying that one of the objectives of the LEB is to provide continuing legal education is to encroach upon the rulemaking powers of the Supreme Court, which already includes the imposition of an MCLE for every member of the bar, Your Honor.
What do you understand by academic freedom, and what are its parameters?
Academic freedom is possessed by all stakeholders in an institution. It is possessed by the institution itself, in that internally the institution can decide which students to accept for their study, which professors to hire, who to hire as professors, and also the curriculum of the school. And of course, the manner of distributing income to the various categories of expenditure in the school. That's insofar as the internal parameters of academic freedom is, as experienced by the institution. It is also experienced by the professor in that he or she should be free to teach the way he wants to teach, as long as the method is not vulgar, the method is germane to the purpose of the professor in teaching. Academic freedom is also possessed by the student in that he is or she is free to choose his chosen field of study and to graduate in that field of study as long as he has no academic deficiency or has not violated any disciplinary regulation in the school. So he should be able to choose that chosen or his preferred field of study and take it to its final stage. And of course, it's also the court also is a stakeholder in academic freedom in that, of course, much as it regulates admission to the practice of law, it also wants to make sure that the people who are mandated to regulate the legal education are people of good moral character, for which reason the applicants to the Legal Education Board are being vetted by members of the JBC, which would be under the Supreme Court, Your Honor.
Recently, Secretary Lawrence of the Department of National Defense abrogated the agreement between the UP and the DND. Has it affected the students' right to academic freedom? Your thoughts on this?
I think not really, Your Honor, because academic freedom is not absolute. And it is the duty of the students as well, especially in an institution which gives free or very minimal, which imposes a free or minimal tuition fee. Not that it is a priority in determining the enjoyment of academic freedom, but it's also the duty of the student to abide by, to be good citizens so that they could be deserving of the free education that they are undergoing. And if they devote their time to activities which are not really related to the school, then I don't think they should be allowed to enjoy those otherwise not those what you call that, those incidents that are not otherwise enjoyed by students in other institutions.
Okay, Attorney Anna Marie, that was my last question.
Thank you, Your Honor.
Thank you and good luck.
Thank you, Your Honor.
Thank you very much. Thank you very much, Your Honor, Judge Timothy Verde. The next to interview Professor Trinidad is Honorable Justice Noel Jimenez Tiham.
Thank you, Attorney Ann. Good afternoon, Dean.
Vice Dean. Good afternoon.
Dean.
Good afternoon, Your Honor.
Vice Dean are two words, so I just said Dean.
Thank you,
Anna Marie. Okay. Can you briefly tell me your understanding of the vision and the mission of the Legal Education Board?
The vision of the Legal Education Board, if I would base it on the written objectives of the Legal Education Board, is to produce lawyers who will, sorry, Your Honor, produce lawyers who are mindful of their role in society and who are ethically fit. Also to train lawyers, to train students in the field of advocacy, in the field of arbitration. Also to make sure that the students are trained to think critically. And of course, in the administration of justice, to train students who will be helpful in the administration of justice eventually. So that's the mission of the Legal Education Board. In other words, to produce students that should be fitting for the profession as well.
What about the mission of law schools? How would you characterize it?
The mission of law schools, of course, is to make sure that the students that they accept would also be ready to participate in society as lawyers when they become lawyers. That first they're able to hurdle the bar so that they can be admitted to the practice of law, because that is, of course, vital to the practice of law. That they would also be, I suppose, the same mission as a legal education board in their very own institution.
What about the mission of a law professor? Is it to educate the students by teaching the law, or is it to conduct recitations to find out if the students have read the law?
I would say that the professor has a dual role in make sure that the student has a good concept, good grasp of the provisions of every field of law. But at the same time, these provisions are going to be useless. The knowledge of these provisions would be useless if the student is not made aware of how, where, and where to apply these provisions. So it's good to mold students as a whole and not to compartmentalize their learning.
But education consists of teaching by the professor, and listening by the students, correct? That's
Yes,
the
Your Honor.
traditional way.
Yes, Your Honor. And I would say that the classroom is they call it the marketplace of ideas. So what we usually or traditionally are used to is the Socratic method, where the teacher determines whether the student has studied his lessons for the day. But I would say that there should also be situations, or there should be activities in which the student can share his or her experience outside law school. And that means that the school should provide enough activities or impose subjects in which the student can learn what really is entailed in the legal profession.
In your opinion, as a dean, is a hostile environment wherein a professor terrorizes a student during recitations and during quizzes to instill fear in their minds and in their hearts, an effective tool to teach those students?
Definitely not, Your Honor. I think that students should be treated by the professors in the same way that children are treated by their parents. If we treat them with hostility, they will return hostility as well, and they'll be hostile individuals. I think that if you use hostility as a method of instruction, at the end of their journey as a law student, they would think that that is the best way to deal even with the persons outside law school, or the people that they'll meet after graduation. I think that if it hasn't worked for me, what has worked for me personally is teaching my students the law without hostility, albeit with compassion. And that way they're able to express what they want to learn. If the atmosphere in a classroom is hostile, there are students who want to ask questions but are afraid that their questions may be perceived as dull and irrelevant. But if you provide an atmosphere where there is shared learning between the professor and the students, after all, there is really no end to learning. Even professors can learn from their students. If you provide an atmosphere which is conducive to shared learning, there is really a lot more that can be gained from it.
How would you address the problem of absenteeism of law professors? And correlated to that is the question, should law professors be engaged on a full-time basis rather than on a part-time basis? since law professors who are also working in government offices, in law offices, or in the judiciary can only spend as much time, only a few time for the education of students in school.
Um, I am very much against as absenteeism in the classroom. The professor, when he or she accepts a course, should be committed to teaching it on time and teaching the course in full. The student will learn only as much as they are enthused by the passion of their professors. And if that is passion, if there's no passion, that can be contagious to the students as well. So I'm definitely not for and very much against absenteeism on the part of the professor. Now, I think being a full-time professor could be an option if such is provided or such is recognized in law schools. To be a full-time professor, that means that the professor is teaching or spending time in school at least 8 hours. He or she is not teaching anything else, or he's not teaching in any other institution of higher learning. So I would recognize that there is much to be appreciated for full-time professors, but that is an option, and that should be really a contractual matter between the school and the professor.
A full-time professor can devote all of his time and energy, correct? Because if you're
Yeah.
a full-time professor coming from another work, then you cannot be expected to devote all of your time and energy.
Yes,
My
Your Honor.
other question is the production of ethical lawyers, should, should it be not a paramount mission and vision of law schools?
I think ethics in the legal profession is underrated. Uh, Most students, or even those outside law school, the ordinary person is amazed by uh, lawyers who they see all the time on television. Sometimes lawyers whom other perceive as great lawyers are just really lawyers who are wealthy and who know their way around. I think ethics should be ingrained in every lawyer, and that should begin in law schools. Ethics, legal ethics, in my opinion, should deserve a more credit than it has in the law school.
Only 5% in
Yes, yeah,
the
even in the bar. And when you think about it, that's where most lawyers fail in their chosen field of practice after hurdling the bar. That's where they fail in the possession of the good outlook and good morals as a lawyer. So there should be a higher percentage given to legal ethics in the bar exams. After all, with respect to other subjects, there are always the books available to the lawyer. They can always scan the books. But ethics is something you either have or you don't. And if you inculcate it early enough in your school program, the chances of the lawyer remembering what is really more important improves.
Now, academic freedom is mentioned in the Constitution as being accorded a constitutional commissioner who later became Justice of the Supreme Court, Adolphus Cunha, explained that since academic freedom is a dynamic concept, he said, we want to expand the frontiers of freedom, especially in education. Therefore, we shall leave it to the courts to develop further the parameters of academic freedom. In your opinion, should it have been Congress who should define academic freedom and not the courts? Because to do so would amount to judicial legislation.
I think the reason why Congress did not define academic freedom is because at the time of drafting the Constitution with academic freedom, there had not been enough cases, or there had not been enough schools in which this could be raised. Presently, too, there are not so many cases on academic freedom, and Congress has left it to the courts to interpret what academic freedom is, even if they had not really defined what academic freedom is in the Constitution. I don't think it will be judicial legislation for the court to define what academic freedom is, because after all, courts have created doctrines based on facts and circumstances in which that doctrine has arisen. So I don't think it's judicial legislation to define what academic freedom is. As a matter of fact, even the ordinary student can say what academic freedom is based on his perception as a student. If he feels that he is not being discriminated against in school, if he feels that he can freely express his views in the classroom, then that student enjoys academic freedom, with or without a definition in the Constitution, or with or without a definition given by the Supreme Court in its rulings. If the teacher doesn't feel compelled to teach in the way that is controlled by outside factors, then the student or the professor will experience academic freedom, again, with or without a definition of such a phrase in the Constitution or in the decisions of the Supreme Court.
Academic freedom should be exercised and respected within the confines of the school, correct?
Yes, Your Honor.
So when a student goes out of school, cuts classes to participate in student demonstrations in the streets to redress perceived grievances, perceived legitimate grievances against the government, is that an exercise of academic freedom, considering that the exercise is done outside of the school?
Academic freedom is, of course, not absolute, just like all freedoms. And with respect to a student, academic freedom is being able to take his preferred course of study and to graduate with obtaining that degree, unless, of course, he has violated a disciplinary measure in the school. But of course, as a concomitant of academic freedom, you also have the freedom of speech. The student should be allowed to express his sentiments in the classroom. Now, should he or she also be allowed to express his sentiments outside the classroom? I don't think that has anything anymore to do with academic freedom, but more of his right to peaceably assemble and redress their grievances before the government. That is not anymore expression or an exercise of academic freedom on the part of the student. And if in the exercise of such freedom to redress their grievances before the government, they fail in their obligations as a student, then it would not be a curtailment of their academic freedom if they are not allowed to finish their chosen course by that school, Your Honor.
When Secretary Lorenzana of the DND unilaterally revoked the Soto-Enrile Accord of 1982 and the Abueva-Ramos Accord of 1989 pertaining to requiring the police and the military to secure prior authorization from the UP president and other officials before they can enter the premises. When Secretary Lorenzana unilaterally revoked that accord, was that an abridgment of academic freedom?
That would not be an abridgment of the academic freedom, in my opinion, because we should consider the circumstances, the time in which Secretary Lorenzana issued that order. This is at the height of perceived communism, where a lot of students from UP have been disappearing, much to the dismay and the heartache of their parents. So to really still require the consent of UP, and to subject this to a hearing would take a lot of time. And meanwhile, the communism in certain schools is certainly on the rise. The recruitment of people or recruitment of students to join rebel organizations is on the rise. And so because of a compelling interest on the part of the state, the unilateral withdrawal or revocation of that contract by the Defense Secretary would be justified and not an infringement of academic freedom. Because academic freedom is not absolute. It is subject to the common good. It is subject to the police power of the state.
Can a law professor teach? Can a professor teach inside a school topics on communism, liberation theology, in the exercise of academic freedom?
Your Honor, I would think that a professor should be allowed to teach communism because that is pure ideology, in the same way that a professor may teach Marxism or socialism, because these are ideological concepts. Now, it is one thing to teach them, but it's another thing to instigate upon their students to participate or to imbibe the virtues or the characteristics, the theories advocated by those ideologies. But to teach them, I don't think that would be an abuse of their academic freedom, Your Honor.
Outside of the confines of the school, can a law professor speak in public about the merits of communism, Marxism, and liberation theology? Will that be in the exercise of academic freedom?
If the professor does that, I don't think that is anymore included in the exercise of academic freedom, because a teacher also represents the school to which he is affiliated or to which she is affiliated or which he or she represents. The utterances of a teacher would be attributed to the school. So the school has a right to a certain degree to prohibit a teacher from teaching that outside the school, because the outside the school is a bigger entity. You cannot control the way of thinking of the people who will hear it, as opposed to teaching it inside the classroom, where the students will be able to see both sides of the picture, will see the disadvantages. But teaching it outside would be another matter, and it could be subject to various interpretations by people, especially those who are not learned and without meaning to be degrading. They would right away think that they would take the ideology hook, line, and sinker, and that is the disadvantage of teaching that outside the parameters of the school.
My last question is, if a school adopts a policy of prohibiting the enrollment of pregnant, unmarried students, is that permissible in the exercise of academic freedom?
I don't think that's permissible, because the pregnancy is it should not be viewed as a disadvantage. Of course, we consider also the age of the student. In a college setting, pregnancy should not be viewed as anything negative. Otherwise, this would lead to unwanted abortions, just so the student could acquire a good education. So you will have clashing interests between the right to life and the right to academic freedom. And we have to avoid that at all costs, because...
What about the dismissal of a faculty member on grounds of morality because the female faculty member became pregnant and the presumptive husband, reneged on his promise to marry the teacher? So everybody in the school knew that they were about to get married. She became pregnant, and the boyfriend reneged on his promise to marry the girl, and the faculty member, the female faculty member, got pregnant. Can she be dismissed from school on grounds of morality? And also in the exercise of academic freedom by the school?
Definitely not, Your Honor. I think the exercise of academic freedom again by a school is not absolute. It it has to be within the parameters of the curriculum, and of course, I would agree that they should hire teachers who are more morally capable or are beyond reproach. But I think in that case, that is a particular case. I think the immorality there is not on the part of the teacher, but on the part of the partner who refused to marry her. Not that marriage should be always accompanying a pregnancy, but I believe that it should be a case-to-case basis. And in that case, it would be really an insult to women because men don't get pregnant. So if they don't want to marry the woman, or if he doesn't want to marry the woman he has impregnated, he could continue teaching. But in that case, the woman who is impregnated by a man who refuses to marry her, notwithstanding her enthusiasm and her decision to pursue with the pregnancy, I don't think she should be castigated for that, Your Honor.
Okay, thank you, Dean Melanie.
Thank you, Your Honor.
Yes,
Thank you, Justice Noel G. Tiham. Our next to interview, Attorney Anna Marie Melanie B. Trinidad, is Honorable Judge Toribio B. E. Ilaw Jr.
thank you. By the way, what's your name? You're new in
Your Honor,
JBC.
Attorney Edith po, Judge Ilaw.
Okay, thank you. Your name again, please. Attorney.
Attorney Melanie Trinidad. Me,
No, no,
Your Honor.
About the host.
Attorney Edith po.
Edith. And who is Attorney Abby? Do you have Attorney Abby? Court Attorney for under Justice Mendoza?
I'm not aware po.
Anyway, thank you. Thank you, Edith. Yes, good afternoon, Vice Dean.
Good afternoon, Your Honor.
Anna Marie Melanie Bacani Trinidad. Bacani, your mother's from Pampanga?
Yes, Your Honor.
How about Trinidad, your father?
My father, Your Honor, is from Bulacan.
Trinidad. Trinidad. No. Okay. The name of your father was Emeterio Altamirano, Trinidad.
Yes, Your Honor.
Altamirano. We have a basketball player by the name of Altamirano in relation to your father.
I am not sure we are related to him, Your Honor. I think that's Eric Altamirano, the basketball coach, Your Honor.
The coach pala, but he was then a basketball player.
Yes, Your Honor.
Coach of Beda?
I'm not sure, Your Honor, but I'm not sure about the school. Not Beda, Your Honor.
It's a professional team also. Anyway, all right, Vice Dean, could you tell us more about yourself? We've just not found in your application requirements.
Okay, I'm a single parent. I have a 24-year-old daughter. I have 3 siblings. I am the second in the family. I am a middle child. I am the daughter of 2 of parents who have, at one point in their lives, devoted their time to teaching. And I am basically a normal person, Your Honor.
Okay. You listed a few significant cases in your PDS. What makes these cases significant? Mostly criminal cases?
as my role in our law office is I am the pleader. I usually just write the pleadings, but a few times I have attended court cases, but they're really far and few in between. The criminal case I've attended their falsification, and maybe one rape case, and a civil case here and there, Your Honor.
You're the partner of the Parulan Soncuya Trinidad Law Office for more than 20 years. Am I correct?
For
Or
18, for 18 years, Your Honor.
18 years. 18 years.
Yes, Your Honor.
What's the first name of Attorney Parulan?
Jerry, Your Honor.
About Soncuya. What's the first name of Soncuya? Attorney Soncuya.
Jose Soncuya, but we call him Bing, Your Honor.
Thank you.
Attorney Soncuya is also from a graduate of San Beda? No.
Yes, Your Honor. Yes, Your Honor, is also from San Beda.
The Vice Dean of San Beda Alabang School of Law. Who is the Dean of the College of Law of Alabang? It's Ulan.
Dean Ulan Sarmiento, Your Honor.
What's the complete name of Dean Sarmiento?
Dean Ulpiano Sarmiento, the third.
The third.
Yes, Your Honor.
Yes, I remember appearing before his father, who was then a CFI judge of Quezon City, and was promoted also to become a justice of the Court of Appeals. All right. What subjects are you teaching in San Beda, Alabang?
I'm teaching criminal law 1 and 2 and criminal law review, Your Honor.
All right, let's go over or browse on your SALN. How come you did not declare cash deposits in your 2020 SALN?
I did declare my cash deposits. They're not significant, but I made sure I declare them, Your Honor.
You did not, but you have a cash bank deposits amounting to around 246,000 as declared in PDS, only in PDS, but not in the SALN.
I am not aware of that, Your Honor. I thought that was I wrote it in the SALN. I filled it up myself. So I will check my copy of that SALN, Your Honor, and rectify what has to be rectified, Your Honor.
Okay. What's your pursuit in the study of law and afterthought? Because you're a graduate of BS. You took up BS Industrial Engineering in college?
Yes, Your Honor.
In what school?
In UST, Your Honor.
By the way, who's the Dean of the College of Law in Mindiola, San Beda?
It is Dean Rocky Del Son, Your Honor. Dean Luciano Del Son.
Rocky.
He is known as Rocky, but his name is Dean Luciano Del Son, Your Honor.
Do you know why he was called, he's called Rocky?
Yes. I think because of the film Rocky and
Rocky Marciano?
Yes, Rocky Marciano. So,
or rather,
I'm sorry, his name is Marciano Del Son, not Luciano. Marciano, thank you for correcting me.
So he was named after Rocky Marciano?
Yes, Your Honor.
Or is it the reason why he's called Rocky is because he came from the mountain province, Rocky?
It could be that too, because that's a fact, Your Honor. So it could be that too.
Correct. As Vice Dean of the Law School, San Beda, Alabang. Wow. The Abbey, we call it the Abbey. Social, huh? Correct. What improvements have you introduced in terms of administration?
I have drafted policies. We have a clinic program, and I've spearheaded it at one point. So I made sure that the clinic program is appropriate for the level of knowledge acquired by the student in the field of law. I have also drafted policies. As you know, San Beda is a a Catholic institution. So I made sure that even as the student pursues law, which should take a lot of his time, that they still observe the practices of the faithful. So I have helped in formulating policies for that, of course, subject to the approval of the dean, which the dean gladly approved, Your Honor.
What was the definition of legal education under Dex Order number 27-1989, as cited in Pimentel versus Legal Education Board, GR numbers 230, 642, and 242954, September 10, 2019.
Legal education was defined there as the pursuit of a study in the field of law, teaching students to exposing them to the different fields of law, in the hope that, teaching them the rudiments of legal practice, such as critical thinking and mediation, conciliation. Legal education is also developing the student to become aware of their role in society.
Not having been a student as well as now a professor in the College of Law, what did you learn in law school subjects that has proven to be the least useful? What are the subjects that you think, in your observation, the least useful?
Negotiable instruments law with the least useful. Negotiable instruments law with respect to provisions on endorsing checks. Although I had a very, very good professor in negotiable instruments law. However, without his fault, some of the provisions had been outmoded even then. Also least useful would be, I think that would be the rules of civil procedure, which were very, very convoluted and very, very complicated then, and of course have now been modified and amended. So that's all I can remember. But of course, at that time, they were useful for a time until their amendment.
Do you think that Roman law was not useful at that time?
Oh, Your Honor, we didn't have Roman law anymore.
Because I still remember that then the late Professor Boy Brillantes told me, June, you were my former student. What subject? Roman law. Oh, matanda ka na. There's no normal Roman law nowadays.
Yes, Your Honor.
Why? Don't you think it's not useful, Roman law?
I think Roman law is has its own, there's something interesting about it. I took Roman law a year ago with the late father. Oh my goodness. Sorry, I can't remember his name. He has just died recently. But for a SEM, I took Roman law and I found it a little bit interesting. But it wasn't included in our curriculum back then.
So aside from negotiable instruments law as well as the civil law procedure, and how could you use your position you're applying for to help law students learn only the useful subjects?
It will have to be in the curriculum. The Legal Education Board, as a supervisory and regulatory body, may really prescribe the minimum subjects that should be taught in law school. And I think those minimum subjects should not be outdated. So I would propose a scrapping of subjects which are no longer applicable in these times. That would be the first thing I would look at, Your Honor.
And what will be the substitute to the negotiable instruments law?
I would suggest some electives. For example, we have environmental law now, which is an elective, but I would increase the number of units for some electives. We don't have a subject on fisheries code or forestry code, which are good laws, although they are special laws, but they are interesting electives as well, Your Honor.
But do you think that the skills which the student develop in law school are suited to the demands of employers and clients?
I would say not, Your Honor. I think we are very good at teaching students concepts, but these concepts remain abstract and remain useless to them until or unless they're able to know where and when to apply these concepts. So I think that it's important that exposure to various fields of law should begin at the first year level. It shouldn't just be an elective, or it shouldn't just be in the fourth year we have the moot court. I think it should be taught almost in every year in the law school out of the 4 years, Your Honor.
I don't know whether I didn't get your answer with respect to the question by Justice Tiam. With respect to what do you think of law school systems which employ mostly part-time faculty? What was your answer then?
His question was, should there be full-time professors in law schools? And I said that would be a matter of choice, and that would be also depending on the law school if they would give preference. And I'm adding this now: if they would give different treatments to those who are going to engage full-time as a professor. Naturally, they'll be giving a lot of work outside school. They'll be giving up their practice because they're supposed to devote maybe a little of their practice because they're going to devote 8 hours of their time in school or something very, very significant amount of time in school. So they should be given a different treatment, of course, a different salary grade as compared to those who are just working part-time, Your Honor.
Do you think the Legal Education Board adds value to the legal education?
I would say it does, Your Honor, because its very objective is to improve the quality of education in the Philippines. Although the Legal Education Board Act came into law in 1993, it became operational only in between 2009 and 2010. That's 10 years. So I think more reforms can be suggested or formulated by the Legal Education Board from here on, Your Honor.
Yes, to enhance legal education in the country, the Legal Education Board was created by Republic Act number 7662. That
Yes,
was
Your Honor.
in 1993. It's already antiquated.
Yes.
The powers and functions of the Legal Education Board, however, mostly, do you agree that involve periodic and not daily tasks, which already been accomplished by the present Legal Education Board, while the others were struck down as unconstitutional? Do you think that the continuous enhancement of legal education deserves more attention?
I think it deserves more attention because there's a lot of room for improvement in the quality of our law schools. We want to be known as not only within the confines of our country, but we want to be known as a quality providers of quality legal education. I think that the Legal Education Board should make issuances or make resolutions that are really doable and well thought of, in order that there's going to be not much time wasted on fighting over the constitutionality of their issuances. I think the Legal Education Board should promulgate laws in their supervisory and regulatory functions that would address the needs of school, Your Honor.
And continuously that since the practice of law, which is the end result of legal education, is imbued with public interest. Do you think that legal education should be made relevant and progressive at all times to address the unique and evolving needs of the legal profession?
Yes, Your Honor. Because, first of all, I think that the law itself should be dynamic and adapted to the evolving times. And if that is the intent of the law, people who will end up practicing it or specializing in it should already have that mindset that it should be dynamic and paramount to public interest, so that it's the duty of the Legal Education Board to make sure that the minimal the suggested curricula of law schools are adaptable to changing times and not really theories in the head. They should really be something that can be appreciated by the average law student.
And how would law schools be able to effectively inculcate quality and responsive legal education to law students?
The stakeholders should really do their job. There are different stakeholders in a legal education. You have the institution, you have the professors, you have the students. It begins with the recruitment of students. Make sure that the students have the aptitude for the rigors of law school. You also make sure that the faculty is committed to providing legal education, quality legal education to the students. And it's only when there is cooperation between and among these stakeholders that you can produce the kind of education that is fit for the times and is responsive to public needs, to public interests as well.
And further, how would law schools be truly responsible in molding their students to become lawyers, or not only competent to handle the bar examinations and prepared for the needs of the legal profession?
I think law schools, at the very least, should increase the number of hours devoted to the study or the subject of legal ethics. Concepts are easy to teach. There are enough subjects in law school, and all these subjects are what they use for the bar. These are required in the bar exams. But what we must inculcate in students is to be really lawyers who are morally upright and would not be a disappointment to the clients that they will meet someday. So the role of the school is to mold not only the mind of the students, but also what's inside them, because the world is a mess already. And so it's easy to find lawyers, but it's hard to find lawyers who are morally competent.
All right, so taking into consideration the landmark decision of the Honorable Supreme Court in Oscar V. Pimentel et al. Versus Legal Education Board, Republic Act number 7662 and the findings of the Legal Education Summit's National Consultative Workshops. By the way, were you a participant in the Summit's National Consultative Workshops?
No, Your Honor.
2 years ago at Manila Hotel?
No, Your Honor. Oh, yes, Your Honor. I think all schools administrators were invited to that, and yes, I participated in that.
Do you think that it's become imperative to consolidate and harmonize all this to the extent possible in light of developments in the education sector and the legal profession to fully develop legal education in the country? Simply, is there a need for the amendment of the present law?
To amend the present law, I think the present law, a lot of the portions of the RA 7662 have already been declared unconstitutional because they infringe on the rulemaking powers of the Supreme Court, but a lot of the portions have also remained. So I think if there would be an amendment, as of now, there need not be any amendment in the law. What should be done is to execute the policies, the objectives of the law. It is reliable as it is. It addresses the needs of the times. And so the thing to do is to implement it and not to amend it, Your Honor.
To be implemented.
Yes, Your Honor.
With so many intricacies, loopholes of the law.
A lot of the loopholes have been pointed out already and already struck down as unconstitutional in the case of Pimentel versus the Legal Education Board. So at the very core of that case is the PhilSat. And the court has said that the giving of an aptitude test is not entirely without good or laudable reason. So I think if we can just find ways of implementing the PhilSat in a way that is not arbitrary, then that is a good jumping start for the improvement of the legal education in the Philippines.
What do you think of the abolition of the top-notcher system?
It has always been every year. Law students have always looked forward to the results of bar exams, and of course, the names of top-notchers are posted almost everywhere. I think it would be a disappointment to those who are doing well in school and who are perceived as prospective top-notchers. But for the most part, I think there are other ways of declaring that a student did very well in the bar exams, which is not to substitute ranking them as 1 to up to 10. The elimination of top-notchers would somehow, I don't think that would in any way detract from the grandeur of the bar exams or the character of the bar exams as the most dreaded bar exams, or really the most sought after exams in any profession, Your Honor. It's just sad for those who are hoping that they would be top-notchers, but for the most part, I don't think it detracts or diminishes the exquisiteness of the legal profession.
And the problem is there's so many who claim to be number 11 position. Because only the 10 top-notchers are only published in the newspaper, also in the media.
Yes, Your Honor. So
everybody's claiming to be
number 11. Yes.
All right, my last question. This may be hypothetical, Vice Dean. A woman gives a beggar 50 cents. The woman is the beggar's sister. But the beggar is not the woman's brother. How come?
The beggar is the woman's sister?
Yes, but the beggar is not the woman's brother. How come?
The beggar is the woman's sister, but the woman is not the beggar's brother. Is that the last? The woman is not
the... It's not the woman's brother.
I would say that the woman's brother, because the woman is not a man, so he cannot be the brother of the beggar, Your Honor.
Or the beggar is her sister.
Yes. Okay. Oh, her, yes. She's a woman, really.
Okay, thank you. That was my last. And
thank
more
you.
in relation to a psychological question, analytical one. Thank you and good luck to your journey.
Thank you, Your Honor.
Thank you, Honorable Toribio E. Ilaw Jr. The next to interview Attorney Ana Marie Melanie B. Trinidad is Honorable Jose Catral Mendoza. Justice Teka, tama ba? JB.
Can you hear me?
Yes,
Thank you
Your Honor.
very much, Attorney Edith.
Thank you, Your
Good
Honor.
afternoon, Attorney Trinidad.
Good afternoon, Your Honor.
How are you? Still strong?
Yes, Your Honor. Hanging on, Your Honor.
Still hanging on. Anyway, I only have few questions for you. You have covered, my colleagues have covered a lot already. I will go direct to the point. What is the constitutional provision on academic freedom? Is it
Academic freedom, there is no definition, as we pointed out earlier, there's no definition of academic freedom really in the Constitution. The meaning of academic freedom has just been provided in a lot of decisions of the Supreme Court.
okay? How many cases have you encountered covering academic freedom?
I have not encountered any case on that, Your Honor.
An academic freedom?
None, Your Honor.
How about Tangonan versus
Oh,
Panyo?
I'm sorry. I'm sorry, Your Honor. I thought you meant have I handled? Yes, I have encountered some cases on academic freedom at
How
Parliament.
about Tangonan versus Panyo? What was the ruling there?
Tarongan versus Panyo. I cannot remember the facts, but if I am told the facts, I would probably remember the ruling, Your Honor.
How about Ateneo de Manila versus Court of Appeal?
Yeah, Ateneo de Manila, I think that is where the court had laid down the parameters of internal parameters of academic freedom, Your Honor. In that academic freedom is to be exercised, is present when there is de facto control over the institution, over the tenure of the professors, the curricula, as well as the distribution of income to various
It refers to the right of the school to dismiss a student for disciplinary disciplinary reasons.
Yes, Your Honor.
Oh, how about Angeles versus Season?
I can't remember the facts. I would know.
Discipline of students also.
The school possesses the authority, the right, and also the duty to dismiss their students who have not complied with the requirements of the academic requirements of the school or have violated a disciplinary measure of the school, Your Honor.
Angeles versus Season refers to the school to take disciplinary action against students for out-of-campus activities but school-related. Now, with respect to academic deficiency, it was the Tangonan versus Panyo.
Yes, Your Honor.
Okay. How about Tangurin versus the recent case of Tangurin versus Gutierrez? I think you know that.
I would know.
Yes.
I would know it if there are so many cases cited in the case of Pimentel versus LEB. I would remember the rulings, but only if the facts are made known to me again. But
well, it covers the NMAT test. Yes.
Yes.
The NMAT was upheld,
yes.
while the PhilSat was not.
Yes.
The Supreme Court gave 3 reasons.
Yes.
Can you name the 3 reasons?
Yes. The reasons that the NMAT was upheld but not the PhilSat was because the NMAT does not really dictate to the school who should be admitted to the medical school. The NMAT is not a pass or fail exam. These scores in the LMAT, the score obtained by the student in the LMAT, will be a tool for evaluation of the student, whether they could be admitted to that particular med school. But in the case of PhilSat, the score of a student falling below 55 means that he or she cannot anymore take law, which would be an infringement of his right to academic freedom. The NMAT also does not, the NMAT also is not the only factor determined by the school in accepting a student. It is up to the school to determine how much weight to give to the NMAT, which is again not the case in the PhilSat. As I've said, it's a pass or fail school, and the institution, the law school, does not have any more opportunity of determining whether this student could be accepted in their school given their PhilSat score, because once it is below 55, that student cannot be accepted anymore. And the last is the NMAT is valid, and the means of implementation of the LMAT is also germane to the purpose of the NMAT, but not so in the case of the PhilSat. The PhilSat is a valid measure because it is a way of determining also the aptitude of the student for the study of law, but the means of carrying out the PhilSat is arbitrary. It deprives the school and the student of their academic freedom, Your Honor.
In Pimentel versus the Legal Education Board, there were two provisions of the law which were upheld or ruled to be constitutional. 4 were held to be unconstitutional. And there were about another 3 or 4 which were ruled as ultra vires. Okay? What provisions were ruled as constitutional?
The provisions that were ruled as constitutional were the right of the Legal Education Board to prescribe to prescribe the LSAT or to hold the LSAT, but not in the manner defined in the law. So the PhilSat, was not entirely struck, but the provision on giving an aptitude test such as a PhilSat by itself was not unconstitutional. Number 2, also the with respect to the
accreditation.
The accreditation, the Legal Education Board has the right to grant accreditation to the school who complies with the requirements for accreditation. And
Which
to
were
remove
struck
such
unconstitutional.
unconstitutional,
What were struck? What provisions were
the provisions that
out?
were struck as unconstitutional is that which referred to the imposition of continuing legal education,
Yes,
number
that's
1.
Yes.
Number 2, also struck as unconstitutional, was the requirements or the qualifications of the professors in the school and their salaries. That was also struck as unconstitutional. They can only prescribe minimum. Anyway, that was struck as unconstitutional.
So being
Also,
an
with
ultra vires.
for being ultra vires, Your Honor.
Yes, the last one you mentioned.
Yes.
How about the other 3?
The
Because
other
one belonged to the group unconstitutional for being ultra vires.
Okay, also as unconstitutional was the one that requires the continuing legal education in schools. That was also unconstitutional.
Yes, you mentioned that number 1 earlier. You mentioned that already.
Also unconstitutional would be that is about as I can remember, Your Honor.
No, anyway, decision which was promulgated last September 10, 2019 is still not final up
No,
to
it's
now,
not yet.
because
Yes.
there have been several motions for reconsideration, questioning everything. Now, I'm asking your opinion anyway. The decision is not yet final. It will not be taken against you. Do you agree with the decision? One by one. Those declared constitutional, those declared unconstitutional. Okay, you first go over those declared constitutional. Do you agree or you disagree?
I would agree that the LEB's right to prescribe to prescribe an aptitude test is constitutional, because an aptitude test is a way of knowing whether a student really can withstand the rigors of the study of law. The aptitude test is a tool which will evaluate the student's capacity for the study of law. So I would agree that that should remain as constitutional. Also constitutional is the right of the LEB to give accreditation to a school and to withhold it if the school no longer conforms with the requirements or with the standards of the legal education board set forth by the legal education board. With respect to the requirements of struck as the following were declared as constitutional. The requirement that the law deans should possess at least one a masteral, that is constitutional, and I would agree with that as well. However, with respect to with respect to the part where law school professors are obliged or are mandated to acquire a master's degree, that was also struck as unconstitutional.
You agree with that?
I do not agree with that, Your Honor.
And you do not?
I do not agree with that. But I just remember that that is one of the provisions which have been struck as.
So you cannot teach in some Beda until you finish your master's. You will agree with that?
No,
if you do not agree with that.
I agree with striking it down, Your Honor. I agree with.
Striking it down,
yeah,
you agree. So
yes,
you agreed.
That
I thought you were against it.
No, I agree that it should be struck
Can
down.
you repeat? Where do you not agree?
I do not.
What what portion of the decision do you not agree?
I am very much convinced by the decision, Your Honor.
In all aspects?
I would say yes, Your Honor. I would say that
so
because
you are a justice, you will not write a separate or dissenting opinion?
I think with respect to, no, I would not write a dissenting opinion. I would agree with that decision, Your Honor.
Yes, totally?
Totally, Your Honor.
Totally, okay. In the dispositive portion, number 3, which were struck down as unconstitutional for being ultra vires. The third one is the act of practice of the Legal Education Board of dictating the policies on the establishment of legal apprenticeship and legal internship programs in violation of institutional academic freedom on what to teach. Recently, the Legal Education Board issued Memorandum Order Number 23, Series of 20, establishing the guidelines for the integration of clinical legal education in the basic law curriculum. What can you say of this?
I think the integrating that in the curriculum.
Are you aware of this Memorandum Order?
Yes, Your Honor, I'm aware of that one. I think integration
of Vice Dean.
Yes, Your Honor. Integration of that in the curriculum is necessary because, as I've said, the students have to be exposed to the what happens really outside the law school. Now, The clinical education program is meant not only to allow the students or to really compel, if you may say, them to assist the indigent, but also teaches them how to write pleadings, how to appear in court. So in that sense, that it's like training, actual training for the practice of law. I would say that that is an agreeable issuance of the Legal Education Board.
In Pimentel versus LEB, it was stated that the state, in the exercise of its reasonable supervision and regulation over education, can only impose minimum regulations. What is your view on this minimum regulation? What is your understanding? Is there a test to determine the minimum regulation?
I think minimum regulations means that it should be limited to supervision and regulation only, as the word itself says. It means that this state should not have, or the Legal Education Board in this matter should not exercise control over the students, the professors, and the institution in the manner by which
it did not state that it did not say that the state should impose control. Only supervision and regulation. In the exercise of its reasonable supervision and regulation,
yes,
can only impose minimum regulation. What is your understanding of this minimum regulation? Are there parameters? There is a test to determine what are the minimum regulations?
Minimum regulations means that they will not infringe on the academic freedom of the professor, the student, and the institution. Academic freedom is an express freedom, just like police power, which allows the state to supervise or regulate education, is also an express power.
So any regulation transgressing academic freedom is not allowed.
Yes, because that would be outside the realm of just supervision and regulation. It would now be bordering on control. And controlling it means taking away their freedom, academic freedom, which is, Your Honor.
Thank you very much, Attorney Trinidad. That will be all.
Thank you, Your Honor.
Okay. You're excused already.
Thank you, Your Honor. Thank you.
That concludes today's public panel interview. Thank you. Thank you and good luck, Attorney Trinidad. And thank you, Justice Mendoza. May all of us have a wonderful evening.
Evening na ba? O 5:30? Nasa office
25
kayo?
ako. Ako po nasa bahay.
Nasa
Work from
bahay.
home po.
Si Attorney umalis na. Oo.
Si Attorney ako po.
Oo. Sige, siguro see you Friday. Friday ang next interview.
Yes po. Sige po. Pahinga na po kayo, Justice.